नमस्कार, हम हैं यहाँ पर टाइम संस्कृति आर्ट्स फेस्टिवल पर और मैं हूँ प्रियंका लाइट एंड शेड्स की तरफ से। हमारे पास आज यहाँ पर है जानी मानी हस्ती नमस्कार, हम हैं यहाँ पर टाइम संस्कृति आर्ट्स फेस्टिवल पर और मैं हूँ प्रियंका लाइटन शेड्स की तरफ से। हमारे पास आज यहाँ पर है जानी मानी हस्ती पंडित राहुल शर्मा।
are the students of international journalism.
This is MGM's community radio.
Over 50 institutions spread across the country. Thousands of people working in unison offering humanitarian services. Lakhs of people have been blessed by these services. All of this made possible by one name, one entity, one institution, MGM. A thought, an inspiration, a kalpavriksha. The Mahatma Gandhi mission is always and forever in pursuit of excellence. 2nd October 1982 marks the beginning of this journey. The foundation of this organization, the Mahatma Gandhi Mission Hospital in Neela, was established. 2 months later, on the 20th of December, the MGM Trust was formally registered. Many minds came together to establish this organization. Many hands lent their strength to lay the cornerstone of the MGM Trust, be it family, friends or colleagues. What is the driving force behind this institution?
The driving force behind Mahatma Gandhi mission is the name of Mahatma Gandhi itself. Mahatma Gandhi philosophy to wipe every tear from every eye. Service to humanity. When we achieved the freedom, he was asked, what is your next mission? What you are going to do? Now the task is over. You have achieved freedom for India. Mahatma Gandhi said, my mission of life is to wipe every tear from every eye of Indians. And we are, with that mission, Mahatma Gandhi mission is working.
This driving force has expanded MGM's reach far and wide across Maharashtra and India, building up a staggering amount of infrastructure of medical health centers and educational institutions. Many factors have contributed to the growth of this institution, some of which have very interesting anecdotes behind them.
कमल बाबूंनी सजेशन केलं होतं की इंजिनिअरिंगच्या ज्या जागा आहेत त्या दुप्पट करा. वसंतदादाला ते पटलं. वसंतदादा त्यावेळेस मुख्यमंत्री होते. मग दादाने डिक्लेअर केलं की बाबा आम्ही इंजिनिअरिंग कॉलेजेस हे प्रायव्हेटमध्ये देणार. कोण कोण तयार आहेत या. कमल भाऊ होते. ते म्हणले कमल भाऊ तुम्ही नुसतं बोलता म्हणले कधी काहीतरी करून बघा. तर ते म्हणले काय दादा ते इंजिनिअरिंग कॉलेज. दादा त्याला खूप पैसे लागतात असं. म्हणजे बोलायचंच काय म्हणले नुसतं बघा म्हणले करून. आता त्यावेळेस योगायोगाने आमची ही ट्रस्ट रजिस्टर झाली होती 1982 मध्ये. त्यांनी एक कागद घेतला असा त्यांच्याजवळ, याच्यावर लिहा अर्ज करा म्हणले. त्यावेळेस काही प्रोसिजर नव्हती त्याची. साध्या कागदावर कमलबाबूचा अर्ज आहे, आम्हाला इंजिनिअरिंग कॉलेजची परवानगी द्यावी.
Covering education from KG to PG, MGM has made strides in creating educational institutions that go beyond the norms and provide education of international standards. Along with education, MGM's is equally focused on providing quality healthcare to the people of Maharashtra. This goal gave rise to a number of hospitals.
We started a small hospital in Aurangabad, that is at MGM Azamnagar, Aurangabad. In 1990, we decided to have a expansion of the health activities, because health is the main problem. People has to go from Nanded, from the rural area of the Nanded district to Mumbai for small business because no facilities were available. So we bought a hospital in Navi Mumbai that is known as Mahatma Gandhi Mission Hospital in CBD.
Among these stalwarts, stands MGM's Institute of Health Sciences, tall and proud. It was recognized by the Department of Higher Education for its unmatched ability to provide quality education, which is why it was bestowed the deemed university status in 2006.
What you need for a university then? Collection of intellectual people which are passionately teaching the undergraduate students, tomorrow's doctors, tomorrow's nurses, and along with it, the research in their own fields. And the whole thing, if you collect together, is a university. Building this thing comes later on, but the critical mass of the intellectual people's collection was the hallmark of the getting us a deemed university status.
This hallmark has led MGM to become a conglomerate operating on a mammoth scale, its largest and most benevolent arm being healthcare, spreading far and wide across Maharashtra.
If you put together these 30 years of service, I think MGM has done almost 25 million patients are seen in the outpatient, and 2.5 million patients are admitted and treated in the hospital premises. With the strength of human resources and the facilities which MGM has provided in the state of Maharashtra, we have served the community.
MGM has 4 campuses across India, 3 in Maharashtra and 1 in Noida, Uttar Pradesh. Let's begin our journey through these campuses. Aurangabad is MGM's largest campus, spread over an astounding 80+ acres of land. It is a fusion of architectural expression and green open spaces. Sitting proudly at the center of this expanse is JNEC, the Jawaharlal Nehru Engineering College. It is one of the first unaided engineering colleges in Marathwada and a testament of MGA's pursuit of excellence in education. It is equipped with modern infrastructure, innovative technology, state-of-the-art workshops, and a force of competent faculty.
JNEC is meant for technology development. JNEC is meant for cohesive mindset for the building the nation and the world together. JNEC is for creating good so that the future world should remember them, and JNEC is there that overall personal development has to be there.
The Medical College and Hospital in Aurangabad was established in 1990. Since then, it has been a pioneer in introducing advanced medical technologies and procedures in Marathwada. It was the first hospital in Marathwada to perform a liver transplant. It is an NABH accredited institution. A plethora of specialty and super specialty departments have made it a premier healthcare facility in Marathwada. Being a trust-run hospital, it has performed thousands of surgeries and OPDs at minimal cost, giving invaluable contributions to charity. Every student that graduates from the medical college is an exemplification of these humanitarian values. All this is only possible because of excellent infrastructure, well thought out facilities, and a compassionate management.
And in MCRI, UV's surgery has been done. We have done the kidney transplant, we have done the liver surgery, bypass surgery we do at least 5 to 6 a day.
We are having 1,000 beds indoor. We are catering to almost 1,500 patients on OPD basis. We are doing almost 50 to 60 diagnostic camp, school health education, adolescent clinics. We are examining almost 25,000 patients per year.
MGM's beginnings were in healthcare. Their first educational institute was JNEC. Slowly, the Aurangabad campus grew to such a vast expanse that it encompassed nearly every need, from that of a just born child to a student being provided holistic education and world-class sports opportunities through a myriad of institutions. These institutions played a major role in their journey. The We Care Daycare Center is a godsend for working parents as cares for their kids as one would for their own child. The Sanskar Vidyalaya is an amazing Marathi medium school with some of the most talented children. The Cloverdale School is a phenomenal amalgamation of modern teaching and educational methods with a keen approach to creativity. They also have school at Valunj, Nimgaon and Gandheli. All these schools not only unlock the hidden talents of their students, but also help them progress through value-based education.
My focus was to give a very good environment where children are, even if they're away from their home, they feel very secure and have a very safe place to learn. So that is why we started working on the pre-primary school first. And once the pre-primary school was set up,
and when I say we are followers of Guru Shishya Parampara, it also means that Mahagami welcomes all the Gurus, and I am also a Shishya.
MGM's College of Journalism and Mass Communication was established in 1993 to create skilled journalists. The Journalism College is equipped with special studios and equipment to ensure that their students get the best possible exposure to the world of media. The institute is NAC accredited.
Hello everyone, this is MGM's Community Radio. We welcome you all. I request you to stay tuned and enjoy 98.0.
They have launched their own community radio in Aurangabad campus.
I, Pranjal, welcomes you in the MGM News. Namaskar, Vaishnavi Rao.
My name is Umar Khan and I would like to give you some description about the course.
The first option is BA International Journalism, which is offered by MGM Institute of Journalism and Mass Communication. ज्या प्रकारे येथे IJ म्हणजे इंटरनॅशनल जर्नलिझम शिकवले जाते, त्याच प्रकारे MCJ म्हणजे मराठीतील जर्नलिझमचा कोर्स देखील येथे घेतला जातो.
जसं स्टीव्ह जॉबनी म्हणजे एक क्रांती केली ॲपल आणून किंवा आपल्या मायक्रोसॉफ्टमुळे क्रांती झाली, तसं MGM जर्नलिझमनी सुद्धा मराठवाड्यातच नाही तर महाराष्ट्रातल्या कानाकोपऱ्यातली मुलं या जर्नलिझममध्ये भाग घेतात आणि ती म्हणजे अगदी महाराष्ट्राच्या बाहेरची सुद्धा. आता यावर्षी तर कलकत्ता, दुबई, सौदी इकडून विद्यार्थी आहेत आपल्या कॉलेजला. म्हणजे एक तर चंद्रपूरवरून विद्यार्थी असतो किंवा अगदी गोंदियामधून विद्यार्थी येतो किंवा मग डायरेक्ट परदेशातून विद्यार्थी येतो. असं कॉम्बिनेशन आपल्या महाविद्यालयाचं आहे. त्यामुळे मला वाटतं की मराठवाड्याच नाही तर महाराष्ट्रातल्या ज्या मुलांना पत्रकारितेचा काहीच माहिती नव्हतं ती मुलं आज म्हणजे खूप चांगल्या दैनिकामध्ये चांगल्या पदावर चांगलं पॅकेज घेतात. ही आमच्यासाठी तर खूप अभिमानाचीच गोष्ट.
The college also offers international courses on the art of filmmaking. For this, they have developed a state-of-the-art studio and preview theatre.
Cinema is an art, and a cinema artist, you need to develop skills for that art.
Hello. A very good evening to everyone present. It is my honor, more than pleasure, to welcome you all to this enlightening evening. Dr. APJ Abdul Kalam has once said, education, in its real sense, is the pursuit of truth. It is an endless journey through knowledge and enlightenment. Today's symposium, which is being conducted on hybrid mode and being streamed live, focuses on understanding the new law from the very learned speakers themselves. I personally am incredibly curious about today's event, and I hope so is everyone present here. I consider it a great honor to welcome the following respected dignitaries and request to kindly take the distinguished seats on the dais. Honorable Justice Shri R.K. Agrawal, President, National Consumer Disputes Redressal Commission, New Delhi. Okay. Honorable Dr. S.M. Kantikar, sir, Member, National Consumer Disputes Redressal Commission, New Delhi. Honorable Justice Shri S.P. Taude, sir, President, Consumer Disputes Redressal Commission, Maharashtra State. Dr. Siddhesh, sir, President, ASI. Shri A.N. Kadam, sir, Chancellor of MGM Trust. Dr. R.B. Bohra, sir, Dean, MGM Medical College, Aurangabad. Dr. Nikhil Gupta, sir, Commissioner of Police, Aurangabad. Dr. R.M. Shinde, sir, President, Maharashtra State Chapter of ASI. Dr. Pravin Suryawanshi, sir, Deputy Dean, MGM Medical College, Aurangabad. Light is a symbol of brightness and prosperity as it expels the darkness and brightens the room with enlightenment and wisdom. To make this evening an auspicious one, we pray to Goddess Saraswati herself and invite her presence to this enlightening evening by lighting the lamp. I request all the respected dignitaries to take their distinguished seats on the dais. I feel extremely privileged and honored to be given this opportunity to welcome you all to this symposium. A warm welcome always ensures a happy event. So, I'd love to proceed with the felicitation. I'd like to request Shri A.N. Kadam sir to please felicitate the following dignitaries. Honorable Justice Shri R.K. Agrawal. Honorable Justice Shri S.P. Tavde. Honorable Dr. S.M. Kantikar. Thank you so much for the honor, sir. I request all to be seated. I'd now like to invite Dr. R.V. Bohra, sir, to do the next honors. Dr. Siddhesh, sir. Shri A.N. Kadam, sir. Thank you so much for the honors, sir. Next, I'd like to request Dr. Pravin Suryawanshi, sir, to do the next honors. Dr. Nikhil Gupta, sir. Dr. R.M. Shinde, sir. Dr. Ravindra Kote, sir. Dr. Ravindra Kote, sir, IMA President, Maharashtra State. Thank you, sir. I'd like to request Honorable Dr. S.M. Kantikar, sir, to felicitate today's esteemed speakers. Advocate Dr. Gopinath N. Shinoy, sir. Senior Medico Legal Consultant. And Dr. Lalit Kapoor, sir, Medical Director and Surgeon at Shakuntala Memorial Hospital, Andheri, Mumbai, Director of AMC India Project and Medico Legal I'd like to request Dr. Nikhil Gupta to felicitate Dr. Sachin Fadnis, President, IMA Aurangabad. Dr. Ujjwala Dahifale, Secretary, IMA Aurangabad. Thank you so much to all the respected dignitaries. I once again welcome you all to this symposium. I would now request Dr. Pravin Suryawanshi, sir, the organizing chairman, to share his valuable thoughts with us.
Namaskar. Good evening. All respected dignitaries on the dais, Honorable Justice Shri R.K. Agarwal, Chairman, Consumer Forum Redressal Committee, Government of India, Justice Honorable Taude Sahib, Dr. Kantikar, Member, National Consumer Forum Redressal Committee, Dr. G. Siddesh, President of Association of Surgeons of India, Dr. Nikhil Gupta, Police Commissioner, Aurangabad, Shri A.N. Kadam, sir, Chancellor, MGM University, Dr. Rajendra Shinde, President, Maharashtra State Chapter of Association of Surgeons of India, Dr. Rajendra Bora, Dean, MGM Medical College, Dr. Kute, President, IMA Maharashtra, Dr. Fadnis, Dr. Ujjwala, Dr. Shenoy, and Dr. Kapoor. All respected senior teachers, Dr. Justice Bora, sir, and dear friends. It gives me immense pleasure to welcome you all for this symposium on ethical and medical legal issues in medical practice. In last 3 years, around more than 3,000 cases, medical legal litigations has been registered throughout India. And this number is increasing day and by every day. The main reason behind this is that lack of communication between doctors and patients and their relatives. Second is lack of adequate documentation, what we do. And the important reason behind this litigation is what we used to say before, that it is a trust or shraddha, what patient used to have with their doctors, that is lagging. And I think for this reason, we both parties are equally responsible. Whatever bond we used to share with our patients in good olden days, that bond is missing. And unfortunately, in these days of commercialization or corporatization, there is a dryness in the relationship between the doctors and their patients. So that is causing a lot of discomfort for the patient themselves also, and for the doctor themselves also, in taking risk in treating these patients. So I feel it's very, today we are very fortunate and very honored to have such a galaxy of speakers across the India to enlighten us on this topic on ethics and medical legal issues. If you are the hall which we are sitting here, its name is Dyotan, and the meaning of Dyotan is a place where you get enlightened. So the Bodhi Vriksha is the Dyotan place for the Gautam Buddha. Same, I think, same way, this Dyotan hall is going to definitely enlighten us on this very important topic of ethics and medical legal issues. Just we were talking few minutes before coming to this hall that ethics, it is not a thing which should be included in the curriculum. It is a thing which should be practiced day and night. It should be inculcated in you from your childhoods. It's not ethics only in your medical profession, but ethics in society, ethics as a citizen is equally important. So though we are going to throw some light, but it is a long journey if really you want to be ethical in your life, not just your profession. So again, with these few words, I'm very grateful all the speakers, especially Dr. Justice Agarwal and Dr. Siddesh for coming all the way and gracing this occasion and enlightening us. Thank you very much.
Thank you so much for your words, sir. For the introduction of guests, I request Dr. Pravin Suryawanshi, sir, Deputy Dean, MGM Medical College, Aurangabad, to introduce Dr. Nikhil Gupta, Commissioner of Police, Aurangabad.
It gives me great pleasure to introduce Dr. Nikhil Gupta, the Police Commissioner of Aurangabad City. He is an IPS officer belonging to 1996 batch of Maharashtra cadre. He has worked as Superintendent of Police in several districts, handling crime and law and order. He has worked in some of the most important places in the state of Maharashtra, handling Naxal and terrorism-related issue, communal and sectarian violence, and serious crimes. He holds a doctorate in environmental engineering and management sciences, apart from qualification in law. He is a Rotary World Peace Scholar and completed a master's degree in conflict resolution from the University of Barford, UK. He is a recipient of number of awards and honors, decorated with Police Medal by the President of India in year 2012 and the Director General of Police Maharashtra's insignia in 2009. He is also a recipient of Weber's Savvy Award and the Commonwealth Association of Public Administration and Management Award for Innovation and Excellence in Policing for his community policing and citizen-centric initiatives. He has contributed extensively on policing and environmental issues in national and international journals and presented papers in several conferences of repute. So with great pleasure, I welcome Dr. Nikhil Gupta for his speech.
Thank you so much, Dr. Suryawanshi, for your kind introduction. All the respected dignitaries on the dais, all the esteemed participants of this seminar present here and attending online, I'm really thankful to Dr. Suryawanshi, MGM, Shri Kadam sir, for inviting me for this discourse, this discussion on a very, very important issue that pertains to various important issues for the doctors whom we consider as God or almost next to God. And some of the issues that are so important, and inviting a police officer to talk about some of the issues, I'm so happy, so thankful. So whenever the discussion of doctor comes, what I remember is my good old family doctor in childhood, to whom all of us, my father, my mother, my grandfather, my grandmother, my brother, my brother's son, so from infant to elders, all of us would go to that family doctor and who would simply ask, Kal kya khaya tha? And what exactly is your problem? And that stethoscope, he would treat most of our problems. And we never doubted our family doctor. We never questioned his ability. We never questioned his ethics. And this went on for many, many years. And then came the development. And then came all the scientific innovations. Of course, all these innovations, all the development is helping our doctors in more accurate investigation, in more accurate diagnosis, in more accurate and better treatment of the patients. But that also brought the issue of ethics in medical practice. So much so that now we have seminars to discuss ethics and, of course, medical legal issues. In last many years, this issue was discussed on many forums, including many issues being taken to the judiciary. And one of the most landmark cases that I would like to quote here is the Spring Meadows Hospital case of 1988, where the Honorable Supreme Court said, and I quote, "The influence exerted by a doctor is unique." Yeah, we'll all agree with that. The relationship between the doctor and the patient is not always equally balanced. The attitude of a patient is poised between trust in the learning of another, that is the doctor, and the general distress of one who is in the state of uncertainty, that is the patient. And such ambivalence naturally leads to a sense of inferiority. And it is therefore the function of medical ethics to ensure that the superiority of the doctor is not abused in any manner. This was 1988. Dr. Suryawanshi just now mentioned more than 3,000 matters are being heard in the court. Definitely something is wrong somewhere, and a discourse like this, definitely we all look forward that doctors spend more time in treating the patient than going to the courts and pleading for their cases. Well, Dr. Suryavanshi also mentioned about in a very nice word. He said trust, Shraddha. And like I mentioned, we had all the trust in this world. We had and full Shraddha on our family doctors. The research in management has beautifully studied what trust is. We talk about trust. We use the word, uska trust nahi hai, uska trust hai. What exactly is this trust? So very simply, mathematically, trust is made up of three components: competency, benevolence, and integrity. All the medical colleges in India and abroad are teaching our doctors competency required. Benevolence, you learn from your family, from your friends, the company you keep, the books you read. Integrity, again, comes from your family background, your upbringing. The research on trust also shows that the trust broken on benevolence or competency can be repaired. Yeah, you can go read more, study more, take a coach, you can improve your behavior, but the trust broken on integrity is absolutely difficult to repair. So here, the research on trust, the management research on trust is a cue for all the doctors. In fact, I always believe that your job and my job is very similar. People come to us, to you and to me, when they are in distress, when they are in some kind of situation where they need some support. And when they come to us, they expect us to treat them well, to treat them with all the integrity. Just now, while coming to this hall, I tried to read the Hippocrates oath, and I found this word, integrity. I think that's the key. And it is up to the fraternity, the doctors' fraternity, the police fraternity, to identify these black sheep, these bad apples, chuck them out, and support, honor, respect all those who are the champions of ethics, and let their number grow. Very quickly, talking about the medico legal issues, I know the most important issue that bothers most hospital and doctors is the allegation of negligence. Instances of relatives manhandling the doctor, abusing the doctors, even trying to damage the property, pressurizing us to file FIR under 304A. Of course, over a period of time, a large number of judgments by Honorable High Courts and Honorable Supreme Court has made it very clear what negligence is all about. And then there were no clear guidelines. 2005, Kapoor sir mentioned about this. Jacob Matthew case, State of Punjab, Honorable Supreme Court said a police officer shall obtain an independent and competent medical opinion, preferably from a government doctor qualified in that branch, who can give an impartial and unbiased opinion before filing any FIR. Honorable Supreme Court also said no routine arrest be made of a doctor. In 2010, of course, Government of Maharashtra came up with guideline by constituting district level committees headed by the civil surgeon to give opinion on any matter where a doubt is raised about the issue of negligence. In 2010, the law on protection of Medicare service, which provides for punishment of 3 years to anyone who indulges into violence or destruction of property. Of course, I agree, and I agree in front of the all the honorable dignitaries, and I believe 10,000 people online are watching. I agree that there is a much need for creating awareness in police fraternity about these provisions. I would say to some extent the awareness has been created, but a long way to go before every policeman understands and implement these guidelines. My only small suggestion is to all the doctors, to young doctors, is please keep the patient and family well informed about what you are doing, what may happen. Please have a good communication skills, which starts with listening. In America, in USA, they conducted a study and found that on an average, a doctor interrupts the patient in 13th second. Oh, I know what is your problem. 13th second. And they came up with a curriculum on what is called as narrative medicine, a 6 months course. And they found that all those MBBS students who opt for this course tend to become more successful, more popular doctors compared to those who do not take such course. So I feel there is a need that at least the young doctors who are still in making undergo such a course, listen to your patient. They are there to seek your help. And I'm sure the trust that is broken because of some individuals and because of some hospitals will be breached, will be repaired very soon, and there will be no need for any FIR to be registered against any doctor or any need to go to court. I again thank Dr. Suryawanshi, Kadam sir, MGM to invite me, and I give all the best to this seminar. Thank you.
Thank you so much for your words, sir. I would like to request Advocate Vikram Kadam to introduce Honorable Justice Shri S.P. Tavde, President, Consumer Disputes Redressal Commission, Maharashtra, Mumbai.
I am proudly delighted to take an opportunity to introduce Honorable Justice Shri Surendra Pandarinath Taude sir. Sir needs no introduction so far as legal fraternity is concerned. Sir is born on 5th March 1960 at Latnagari. Sir has completed BCom from KJ Somaiya College, Mumbai, and LLB from New College, Mumbai. Sir comes from a family of lawyers and judicial officers. Sir started practice in the City Civil and Sessions Court, Mumbai, and Metropolitan Magistrate Court, Mumbai, from July 1984. Sir joined judicial service as Civil Judge Junior Division and JMFC on 3rd September 1990 and worked as various locations in Maharashtra. Sir came to be promoted as ad hoc additional district judge in May 2001 and further as a district judge in December 2007. Sir has served as principal district judge at Usmanabad and Sangli. Sir also served as joint secretary law and judiciary department, Mumbai. Sir also served as registrar.
Maharashtra Consumer Act. And in those cases, I think in Maharashtra there are many cases filed which are connected with the present topic or symposium, and we are rather helpful. Rather, we will be getting more enlightened on the subject. The subject is ethical and medico-legal issues in medical practice. We are dealing with the act wherein two aspects are very important. One is deficiency in service and other is unfair trade practice. The first part, deficiency in service, can be sorted out by perusing papers or whatever the treatment given by the doctor is always on a paper. So we get that information easily. But as far as the unfair trade practice is concerned, it is very concern for me because there are many aspects are involved in that part. Not only the trust, as Dr. Nikhil has Gupta has enlightened us on that point. Trust is always there because we used to believe our family doctors years together, and we never had any doubt in our mind regarding treatment given by him for any member of our family. But now that concept is now going out. We are going to experts nowadays due to the modern technologies. We are not against the technology, but there are some part involved. Third party is involved is the insurance. There are some flagships in insurance field also. They play major role in the fixing of doctors or settling the bills. And then after, if patient loses, the relative loses their patient, then they say that we spend on this amount and how he has died. The question arises the trust on doctor, trust on insurance, and the treatment given to the patient. So unfair practice is very difficult to explain. But if we see the papers, sometimes we doubt how this doctor has fixed into it, because he has no way concerned with the insurance and other aspect of a patient's financial condition. What suppose if he dies, then they come with the different story, and then very difficult to explain for a medical practitioner, hospital, or consultant also, because third person involves in the matter, and then the matter gets aggravated and very difficult to explain. Even the lawyers also sometimes they get fixed with the taking defense of a medical practitioner. So we can avoid, doctors can avoid some sort of a tripartite agreement between patient, insurance, and the hospital. And if, because almost 90% cases, the patients are now taking medical claims. So we can get that policy first verified. We need not exhaust that policy, because major allegation against the medical officers or medical practitioners is that they, till the end of that policy, they treat and then they say that patient is out of, now is not, we cannot help that patient. The policy of 5 lakhs, they make a bill up to 5 lakhs and then say go to some other wells. So these are the things which we should need take care of, medical practice should care of. We should not go for the policy, what capacity of financial capacity for medical that patient. We should treat them and then other aspect can be seen. Because most of the cases which are coming in these lines also, as Gupta sir has already pointed out, that there is trust. And the first part I said, the deficiency in service can be sorted out by reading all these things, because we see the treatment given, then we get a expert's opinion, and uh, uh, we can hold that way. He was not negligent or not grossly negligent. But the second part is very important, and I think we should dwell upon that point, and we should have some uh, guidance from the speakers today also, because that part is also there. This, Dr. Kantikar is, I think, speaking on that point. And uh, I have nothing to add more in that. So I give all, I thanks to Dr. Shinde. I thank to Pravin Suryawanshi for calling me here. I uh, give all best wishes to this symposium, that at least while going out, we'll get something, and that will help me also, my colleagues also, and of course, the participant also. With this, I conclude and I say thank you. Thank you very much.
Thank you so much for your words, sir. I'm sure everyone is going to learn something out of this. I would now request Dr. R.M. Shinde, President, Maharashtra State Chapter of ASI, to introduce Dr. G. Siddesh, President, Association of Surgeons, India.
Good evening, everybody. It gives me immense pleasure to introduce Dr. G. Siddesh, sir, President, Association of Surgeons of India, which is one of the largest association of surgeons in the world. Sir is the medical director and senior surgeon at Sigma Hospital, Mysuru. He has trained and taught many postgraduate students and budding surgeons as Dean of Faculty, JSS University, and Head of Department Surgery, JSS Medical College, Mysuru. He is pioneer in laparoscopic surgery and GI endoscopy in Mysore region. He is Vice President of Mysore Association of Hospitals and Nursing Home. He is associated with IMA Mysore. Sir is Vice President of Baden-Powell Education Society. Being founder trustee and president of Saptaswara Bagala Trust, he is sponsoring and teaching Hindustani music to children. He himself is a tabla exponent. He has received award from President of India, Sri V.V. Giri, for leading Boy Scout contingent in 1972. He has keen interest in mountaineering and tree plantation. He every year plants hundreds of trees, and he is an environmentalist. With these words, I request our beloved National President to share his thoughts. Dr. G. Siddesh, sir.
Thank you for those kind words, Rajendra. Dignitaries in the dais, I don't want to take much of the time because there is a very important program to follow. We are eagerly looking forward. But as a invitee and also the head of the Association Surgeons of India, it really gives me a duty to share some of my thoughts to this august guardian audience. Well, when I started my practice way back in 1985, December, when I returned back from Mumbai after getting trained in gastroenterology under renowned gastroenterologist, GI surgeon, Dr. V.N. Shikhande. Well, I thought because of what
preachings and the way we imbibed knowledge from these great stalwarts, I understood if I follow ethics and practice what I have gained within the compass of my knowledge and my skill, I will not have to face any medical legal issues. This was my strong belief. And believe me or not, till 35 years, I didn't have a single patient going or question. There are various ways they come and talk to you, they express their slight displeasure or whatever it is. But that is all what we had. No medical legal issue going to the court or a confrontation of any major kind. But at the end of 35 years, last year or previous 2 years ago, I had my first medical legal issue. So friends, here we are standing to think what is that this has changed. Has it that Dr. Siddesh has become more unethical? Has it that his competency has gone down? That which made this patient to go against him, who has been a loyal patient, who has brought his 8 or 9 patients and got operated or whatever various treatment done under me of his family members. What induced this to happen? So, well, let us first understand the basic. There has been a change which is happening in the relationship, which has been highlighted by so nicely by Dr. Pravin Suryawanshi. Well, what is that? What is the change which has happened? And what is the root cause for it? If you look back, I think that there is a huge advancement which has occurred in the progress, and India has not fallen back in that. Today, so to say, like Dr. Efficiency and the skill of Dr. Pravin Suryawanshi, what we have, he is one of the most pioneers looked upon is at the world level. So such great surgeons are there throughout India now. So that makes us to feel proud that Indians and healthcare scenario in India is looked upon by even the West to come and learn some skills from Indian surgeons. So this is what I feel. So well, such great advances have happened not only all over the world, but also in India in skill development and also in the technological advances. India has not fallen back. We have hundreds of robotic surgical centers which has come up. So I'm sure robotic surgery number of centers, if you look at, we have one of the highest in the world. So that is what progress has happened in India. Now, let us now accept that we are progressing so fast in giving healthcare to the people. And we also have seen today our police officer, Mr. Nikhil Gupta, having told us that as a child, he remembers going to a family physician, but I'm sure he will also remember we paid such family physicians a sum of 2 rupees or 5 rupees as a consultation. So today, you know why there is a aspiration for getting the best of the healthcare, because not only there is an advancement, but also people at large, they are become aware of the available best facilities because of the media, because of the information which is there at their fingertips. So they know there is a facility and this is what I can get. They can aspire for it. There is absolutely no wrong in that aspiring. Even the most poorest of the poor in our country deserve the best of the treatment. Well, but what is the cost attached to it? So there is a huge gap which has got created between what a common man can aspire to get in the healthcare and what he can afford. So that gap is one which we need to be thought about, is a major change which has occurred over the last couple of decades, which has resulted in this, put in a seed of mistrust in the field of the relationship between doctor and the patient. So this is a change which we really think about, we had to think about. And here is where the policy making of the government matters. We have been talking how much does the government spend on the healthcare system of the total GDP. Have you ever thought, have we ever compared ourselves to the other countries who are not doing so well economically strong like Malaysia? You go to see, you think about these things. as a common man, we also have a responsibility to look at these aspects. So the root cause lies somewhere else. It is not just that we know there is a law to govern our practice, and whenever there is a mistake, we catch them and punish. So, well, there are terrorists, the root cause, unless the reason for what terrorism has occurred, if we don't tackle, we just identify terrorists and kill them, that is not going to be the permanent solution for our problems. That's my strong belief. Now, coming to the other change which we need to understand is the corporate culture. There is absolutely nothing wrong in the corporate culture. We welcome because it brings in together the quality, the opulence, and we aspire. We need to go and get that quality healthcare, which is otherwise cannot be created overnight by the government setup. And we know the limitations, keeping all the points in mind. So corporate culture or corporate setups are a welcome boon to our country. But now, what is the issues which we need to be wary about? The associated problems of the dubious way of marketing which is attached to it. And friends, today let me share one point when I was lucky enough to interact with the Central Health Minister. He's a very upright person, Dr. Mansukh Mandavia. He gave me an opportunity to express and gave 5 minutes time I requested, told only one point I need to request. It was on the occasion of the foundation day of the Academy of Medical Sciences at New Delhi, and where I could express him that when he expressed medical profession is not a lucrative profession to make money, and it is a service oriented profession. I just asked, yes sir, we are very much with you, we are agree with you 100%, all doctors will agree. Sir, then what is this business people are doing in our profession, doing the marketing? You heard of, I cannot take these names, I don't know whether Sir Gopinath will tell me with his right to tell the names of Pristine and other similar, they are so well established. I just requested him, why can't you make it, brand them as illegal and put an end to that? Because just now we read the Hippocratic Oath, which is so nicely depicted in the library in this down, one floor down. I will tell you, to market is our science is illegal. It is unethical. So where are these agents to get patients to doctors? So there cannot be commission agents to get doctors to us. So this is what. So now the policy has come in. NMC draft proposal which has come says, well, it is not correct to have middlemen bringing cases doctors. So what is the law says? Law says doctors should not accept patients from commission agents. Well, is it the right way to look at things? It's simple one-liner. These people are illegal. Make it, and that is the end of it. So why can't we think about more radical policies? What is the reason why a government cannot make such policies? You need to think about it at a much larger perspective. Thank you very much. These are few thoughts, and there are so many other things which I'm sure I will have an opportunity to discuss at the last stage of this symposium, where we have a scope for interaction. I'm sure Dr. Pravin Suryawanshi has got all these points in mind. We can have more elaborate discussion during the symposia. And I take this opportunity to congratulate the MGM Medical College, Kadam sir, for giving an opportunity to host such a nice symposium, which is very essential to create awareness. If not anything, we may not be able to convey everything what is required in ethics and also medical legal aspects. I'm sure the experts in the field, sir, Justice Honorable Agarwal sir has traveled all the way from Delhi. Sir, with such dignitaries on as a panel of our experts available to us in the symposium, we sure going to bring in certain messages to the audience at large. But I take this opportunity again to congratulate Pravin Suryawanshi. He is one guy. He is an executive committee member for the second term in the Association Surgeons of India, representing Maharashtra, and we have allocated certain responsibility among ourselves. And he is one who was one of the very few who have taken up this allocated responsibility fully And this is one evidence that he has taken up, and he has proven his caliber as a leader to show that he can, when he takes a responsibility, he will execute it. So that is like a good, successful surgeon. I congratulate him again, and thank you for organizing this event. Hopeful that the membership of Association Surgeons of India will benefit from this, and also to say that this will be available on our website. I'm sure the link to the YouTube is always there. For those who missed out, pass on the message. They can always look in at their leisure time. And also thank Dr. Rajendra Shinde, who is the president of the Maharashtra State Chapter. He has got a very important year to go ahead. You are lucky that in your tenure, we are going to host the ASICON in the state of Maharashtra at Mumbai. So that's going to be a very important event, and I'm sure this will be a permanent memory in your life for that to achieve. I wish you all the best for that event and also for your tenure. Thank you, all of you, and the eminent faculty who have joined in to be part of this program. Thank you very much for patient hearing.
Thank you so much, sir. I would now request Honorable Srimati Pratibha Patil ma'am to introduce Honorable Shri Justice R.K. Agrawal, President, National Consumer Dispute Redressal Commission, New Delhi.
Namaste. It's my great privilege to introduce Honorable President of National Consumer Dispute Redressal Commission, Mr. Justice Rajesh Kumar Agrawal. Lordship hails from Allahabad, Holy City, Uttar Pradesh. Graduated in law from Allahabad University. Enrolled as an advocate on 14th August 1976. Joined the chamber of his father, Sri Rajaram Agrawal, Senior Advocate and former Advocate General of Uttar Pradesh. During practice, Lordship dealt with constitutional, company, service, educational, and taxation matters. Worked as a standing counsel of the Income Tax Department of Government of India and served as joint editor of UP tax cases. On 5th of February 1999, Lordship was elevated as a permanent judge of the Allahabad High Court and assumed office as acting Chief Justice, High Court of Madras. From 24th October 2013, assumed office as Chief Justice, High Court of Madras. Lordship was appointed as the Judge of the Supreme Court of India on 17th February 2014 and retired on 4th of May 2018. Presently, since 1st of July 2018, Lordship is the President of National Consumer Dispute Redressal Commission at New Delhi. As the Chief Justice of the Madras High Court, a bench headed by Justice Agrawal delivered the historic interim order permitting a transgender to write the state's competitive examination under the women's category. The bench ensured that the hall ticket was handed over to her at the court hall itself. Honorable Lordship constituted the Gender Sensitization and Internal Compliance Committee, making the Madras High Court the first High Court in the country to do so. Honorable Lordship was a part of the 9-judge bench of the Honorable Supreme Court that was constituted in the case of Justice K.S. Puttaswamy versus Union of India, where the bench unanimously declared the right of privacy a fundamental right enshrined under Article 21 of the Constitution of India. Thank you. I invite the Honorable Lordship to.
Dear friends, a very good evening to all of you. I am extremely delighted to be here to participate in the Symposium on Medical Ethics and Legal Practice. At the outset, I must appreciate the efforts of the organizing committee for having such a grand symposium on the aforesaid issue, especially in the light of the sizable number of judgments during the last few years passed by the Honorable Supreme Court of India and the National Consumer Dispute Redressal Commission on medical negligence and awarding unprecedented compensation, as was done in Balram Prasad versus Kunal Shah, 2014, Volume 1, Supreme Court Cases 384, and Nizam Institutes of Medical Sciences versus Prashant S. Dhananka, 2009, Volume 6, Supreme Court Cases, page 1. I can easily understand some kind of nervousness in the minds of the doctors when they narrate the kind of allegations of medical negligence they have to face and the quantum of monetary compensation being awarded. Friends, George Bernard Shaw famously remarked, I quote, "We have not lost faith, but transferred it from God to the medical profession," unquote. This is the kind of expectation that we have from the medical profession and the kind of burden that we place on the shoulders of the doctors. Medical profession is considered as the most noble and service-oriented liberal profession, having a self-regulating code of ethics, and the doctors have always been compared and equated next to God. The principal objective of the medical profession is to render services to the humanity with full respect to the dignity of men. Having realized the importance of medical profession, Terry Pratchett, the English author, quoted, I quote, "It seems sensible to me that we should look to the medical profession that over the centuries has helped us to live longer and healthier lives, to help us die peacefully among our loved ones in our own home without a long stay in God's waiting room," unquote. It is true that because of the increased awareness regarding patients' right lately, there has been an increase in litigation relating to redressal for the suffering caused due to medical treatment, diagnosis, vitiated consent, etc. This positive patient-centric initiative of rights protections need to be appreciated in the context of lack of quality public health services on the one hand and massive private investment on the sphere of the healthcare systems on the others, coupled with the Honorable Supreme Court's painstaking efforts to constitutionalize the right to health as a fundamental right, thereby guaranteeing healthcare to all. It is equally essential to emphasize that the protection of patient rights is not to be at the cost of professional autonomy. Hence, undeniably, there is a need to harmonize the guarantee of best healthcare with the right to medical professionals. The medical practitioners need to be reassured that every act of theirs is not under scrutiny all the time. What the consumer protection law is trying to achieve is a protection of the genuine rights of the patient. A patient generally approaches a doctor or hospital based on his or its reputation. Expectations of a patient are twofold. One, doctors and hospitals will provide medical treatment with all the knowledge and skill of their command. And second, they will not do anything to harm them in any manner, either because of their negligence or careless attitude or of their staff. Though a doctor may not be in a position to save this patient's life at all times, he is expected to use his special knowledge and skill in the most appropriate manner, keeping in mind the interest of the patient who has entrusted life to him. The provision of the Consumer Protection Act was introduced or held applicable to the medical profession by on account of a decision of the Honorable Supreme Court given in the case of Indian Medical Association versus VP Shanta and others, 1995, Volume 6, Supreme Court Cases 651, wherein it was held that the doctors render service if anything is charged, and therefore they come under the definition of the word consumer or service provider under the provision of the Consumer Protection Act. Recently, as you may be aware, the Bombay High Court in public interest litigation number 58 of 2021 titled Medico's Legal Action Group versus Union of India decided on 25th of October 2021 as held that mere repeal of the 1986 Act by the Act of 2019 without anything more would not result in exclusion of healthcare services rendered by doctors to patients from the definition of the term service. And the special leave petition filed against this order of the Bombay High Court has been dismissed. After approaching to a doctor, the patient feels himself in safe hands because he believes that his disease will be cured and he will be healed by the medical treatment. But sometimes even the doctor makes mistakes which can cost a lot to the patient in many ways. Sometimes the mistakes are so dangerous that a patient has to suffer immensely. Mistakes or negligence in medical profession may lead to minor injuries or some serious kinds of injuries, and sometimes these kinds of mistakes may even cause death. Since no man is perfect in this world, it is evident that a person who is skilled and has knowledge of a particular subject can also commit mistakes during his practice. The fundamental reason behind medical error or medical negligence is the carelessness of the said doctors or medical professionals, and it can be observed in various cases where reasonable care has not been taken during the diagnosis, post-operative care, procedure without required diagnosis and investigations, over-medication, transfusion of infected blood, anesthesia error, and more particularly, absence of informed or real consent, etc. The question as to what constitutes medical negligence based on the touchstone of Boehm's test has been well settled by the Honorable Supreme Court in category of judgments, including the leading one is Jacob Matthew versus State of Punjab and others, 2005, Volume 6 Supreme Court cases, page 1, and it has recently been followed in Dr. Mrs. Chanda Rani Akhori and others versus Dr. M. A. Mithu Sethupati and others, civil appeal number 6507 of 2009, decided on 20th of April 2022. In Boehm's case, which is oft-quoted as Boehm test, generally accepted as true enunciation of the meaning of the expression negligence by the medical practitioners. McNear J. had said, I quote, in the ordinary case which does not involve any special skill, negligence in law means this: some failure to do some act which is a reasonable man in the circumstances would do, or doing some act which a reasonable man in the circumstances would not do, and if that failure or doing of that act results in injury, then there is a cause of action. How do you test whether this act or failure is negligent? In an ordinary case, it is generally said that you judge that by the action of the man in the street, he is the ordinary man. In one case, it has been said that you judge it by the conduct of the man on the top of a Clapham omnibus. He is the ordinary man. But where you get a situation which involves the use of some special skill or competence, then the test as to whether there has been negligence or not is not the test of the man on the top of a Clapham omnibus, because he has not got this special skill. The test is the standard of the ordinary skilled man exercising and professing to have that special skill. A man need not possess the highest expert skill at the risk of being found negligent. It is well established law that it is sufficient if he exercises the ordinary skill of an ordinary competent man exercising that particular art. Unquote. In the case of Kusum Sharma, the apex court has held that while deciding whether the medical professional is guilty of medical negligence, following well-known principles must be kept in view. And it has been deciphered as 8 principles. I am not reading it. You can see in that Kusum Sharma's case. The apex court in the case of Arun Kumar Manglik versus Chirayu Health and Medical Private Limited, 2019, Volume 7, Supreme Court cases 401, while referring to the above principles laid down in the Kusum Sharma's case as held, I quote, in our considered view, the aforementioned principles must be kept in view while deciding the cases of medical negligence. We should not be understood to have held that doctors can never be prosecuted for medical negligence. As long as the doctors have performed their duties and exercised an ordinary degree of professional skill and competence, they cannot be held guilty of medical negligence. It is imperative that the doctors must be able to perform their professional duties with free mind. Unquote. Recently, the Honorable Supreme Court in the case of Maharaja's Agrasen Hospital and others versus Rishabh Sharma and others, 2020, Volume 6, Supreme Court cases 501, has observed, I quote, medical negligence is the breach of a duty of care by an act of omission or commission by a medical professional of ordinary prudence. Actionable medical negligence is the neglect in exercising a reasonable degree of skill and knowledge to the patient to whom he owes a duty of care which has resulted in injury to such persons. The standard to be applied for adjudging whether the medical professional charged has been negligent or not is the performance of his duty would be that of an ordinary competent person exercising ordinary skill in the profession. The law requires neither the very highest nor a very low degree of care and competence to adjust whether the medical professional has been negligent in the treatment of the patient. Unquote. Recently, the Honorable Supreme Court, while dealing with the question of medical negligence, has referred to its earlier judgment delivered in the case of Jacob Matthew and Kusum Sharma and has held as follows. I quote, in a recent judgment in Dr. Harish Kumar Khurana versus Jogendra Singh and others, 2021, Volume 10, Supreme Court Cases 291, this court has held that the hospitals and doctors are required to exercise sufficient care in treating the patient in all circumstances. However, in an unfortunate case, death may occur it will be necessary that sufficient material or medical evidence should be available before the adjudicating authority to arrive at a conclusion that the death is due to medical negligence. Even death of a patient cannot, on the face of it, be considered to be medical negligence. The term negligence has no defined boundaries, and if any medical negligence is there, whether it is pre or post operative medical care or in the follow up care, at any point of time by the treating doctors or anyone else, it is always open to be considered by the courts or commissions, taking note of the exposition of law laid down by this court, of which a detailed reference has been made, and each case has to be examined on its own merits in accordance with law. Unquote. Medical negligence comprises in the following constraints. First, a legal duty to exercise due care on the part of the medical professional. Second, failure to inform the patient of the risks involved. Third, the patient suffers damage as a consequence of the undisclosed risk by the medical professionals. Fourth, if the risk had been disclosed, the patient would have avoided the injury. And fifth, breach of the said duty would give rise to an actionable claim of negligence. The cause of action for negligence arises only when damage occurs, since damage is a necessary ingredient of this tort. In a complaint of medical negligence, the burden is on the complainant to prove breach of duty, injury, and causation. The injury must be sufficiently proximate to the medical practitioner's breach of duty. In the absence of evidence to the contrary adduced by the opposite party, an inference of causation may be drawn even though positive or scientific proof is lacking. Friends, as I understand, the lack of communication between the doctor and the patient is a major cause of discontent or dissatisfaction with the treatment given by a medical practitioner. The complications or unforeseen danger associated with the treatment procedure should be explained to the patients or their relatives. There has always been a debate on the nature and extent of information that is required to be disclosed by a doctor to secure a valid and informed consent from a patient. Every adult human body with a sound mind has a right of self-determination and personal autonomy to decide what shall be done with his own body, a fundamental aspect of the right to health. The basic principle which permeates through all cases. The basic principle in regards to patient's consent may be traced to the following classic statement in Cardozo in Slendor versus Society of New York Hospital 2001 NY 125. I quote, every human being of adult years and sound mind has a right to determine what shall be done with his own body, and a surgeon who performs an operation without his patient's consent commits an assault for which he is liable in damages. Unquote. Friends, but this will not apply in a case of an emergency requirement of conducting some operation on the operation table, even when the patient is unconscious or the attendants are not available. So the doctor has a right to take steps to save the life of the patient. Friends, based on the developments domestically and internationally on the point, the word consent has now been assumed, the nomenclature's informed consent. The Bolam test, accepted and applied in a catena of pronouncements by the Honorable Supreme Court as a measure of doctor's duty to disclose information to the patient without potential consequences and risks of proposed medical treatment or diagnostics, has undergone a radical change in the country of its origin, that is the United Kingdom. In the case of Montgomery versus Lanarkshire Health Board, Scotland, 2015, UKSC, page 11. After Bolams, in Canterbury versus Spence, 150 US App, DC 263, 1972, the United States Court of Appeal had observed that it is normally impossible to obtain consent worthy of the name unless the physician first elucidates the options and the perils for patients' edification. Thus, the physician is a long borne a duty on pain of liability for unauthorized treatment to make adequate disclosures to the patient. But in Sidaway versus Board of Governors of Bethlehem Royal Hospital, 1985, Volume 1, All England Reports, 643 House of Lords, per majority, the House of Lords performed Bolam test as a measure of doctor's duty to disclose information about potential consequences and risks of proposed medical treatment. The stringent standards regarding disclosure laid down in Canterbury were not accepted. However, after the majority opinion in Sidaway rendered in the year 1985, in Montgomery case, the question of a doctor's duty to advise a patient of risk involved in treatment came up for consideration before the United Kingdom Supreme Court, making a significant departure from the majority opinion of the House of Lords in Sidaway's case, which has followed Volam by a unanimous opinion. The court has now approved the following minority opinion of Lord Scarman in Sidaway. I quote, to the extent that I have indicated, I think that English law must recognize a duty of the doctor to warn his patient of risk inherent in the treatment which he is proposing, and especially so if the treatment be surgery. The critical limitation is that the duty is confined to material risk. The test of materiality is whether, in the circumstances of the particular case, the court is satisfied that a reasonable person in the patient's position would be likely to attach significance to the risk. Even if the risk be material, the doctor will not be liable if, upon a reasonable assessment of his patient's condition, he takes the view that a warning would be detrimental to the patient's health. Unquote. Inter alia, observing that the paradigm of the doctor-patient relationship implicit in the speeches in Sidaway has ceased to reflect the reality and complexity of the way in which healthcare services are now provided, or the way in which the providers and recipients of such services view their relationship, as also a wider range of healthcare professionals now provide treatment and advice of one kind to another. It has been opined, I quote, it follows that the analysis of the law by the majority in Sidaway is unsatisfactory insofar as it treated the doctor's duty to advise a patient of the risk of proposed treatment as falling within the scope of the Bolam test, subject to two qualifications of that general principle, neither of which is fundamentally consistent with that test. It is unsurprising that courts have found difficulty in the subsequent application of Sidaway, and that the courts in England and Wales have in reality departed from it, a position which was effectively endorsed particularly by Lord Steyn in Chester versus Upshur. There is no reason to perpetuate the application of the Bolam test in this context any longer. So if the United Kingdom has itself made a departure from the Bolam test, time has come when the Honorable Supreme Court should also follow it and make a departure which will be in the interest of the medical profession. Nevertheless, so far as our country is concerned, the concept or principle of consent, informed consent or real consent, whatever expression one may like to use, is to be examined on the touchstone of the principles lucidly enunciated in Samira Kohli versus Dr. Prabha Manchanda, 2008, Volume 2, Supreme Court Cases, page 1. But that also requires a change in view of this recent progress made, or rather the departure made by the United Kingdom, where the Bolam test had enunciated. Thus, fundamentally, the law requires the disclosure to the patient information relating to the diagnosis of disease, nature of the proposed treatment, potential risks of the proposed treatment, and the consequences of the patient refusing the suggested line of treatment. Disclosure or explanation of such information to the patient by the treating doctor and the patient's conscious decision in this behalf before venturing into the suggested procedure treatment is the basic attribute of an informed consent, which is considered mandatory every field of surgical procedure intervention. The only exception to this general rule is the emergency medical circumstances, when either the patient is not in a medical condition or mental state to take a conscious decision in this regard. Undoubtedly, doctors are so busy and occupied that they are unable to focus on little but important things like communicating with patients and assuring them of the procedures and medication involved. Very often, patients are often left in the lurch to take extremely complicated decisions on which the life and death of their loved ones turn. Patients have no ability, information, or experience to take informed decisions in such difficult circumstances, and the only individuals who can assist them in this decision-making process are the doctors. As such, open and honest communication rooted in kindness and respect is vital to fostering positive patient-physician relationship. When patient feels that physicians generally care and have their best interest in mind, they tend to be more forgiving. The importance of communicating effectively with parents and their families cannot be emphasized enough. It is one of the best ways to mitigate risk of litigation. The failure to obtain informed consent can be a form of medical negligence or may give rise to a cause of action for medical battery. Friends, managing patients' expectation throughout the entire process is essential in regards to avoiding a malpractice claim. Here I would like to quote the profound words of William Osler, one of the 4 founding professors of Johns Hopkins Hospital. I quote, "The good physicians treat the disease, the great physician treat the patient who has the disease." Friends, the Honorable Supreme Court, in the case of Federation of Obstetrics and Gynecological Societies of India versus Union of India, 2019, Volume 6 Supreme Court cases, 283 has held that considering the nature of services rendered by medical professionals, proper maintenance of record is an integral part of the medical services. As per the Indian Medical Council regulations, all the hospitals are liable to maintain the medical records and provide the same to the patients or the attendants within 72 hours of the request. Last but not least, we need to reassure both the patients as well as medical professionals that the law is only the means to protect the innocent. All efforts of adjudicatory bodies are directed only towards penalizing errant medical professionals and not look upon every medical professional as a suspect. We cannot deny the noble intentions of majority of the doctors who, like God, are dedicated to us preservation of life. I am confident that if the principle of medical negligence laid down by the Honorable Supreme Court are followed in their letter and spirit, the medical profession has nothing to fear and breathe freely. After all, to borrow the classic general definition of physician's legal responsibility as observed in Der versus Bonney, 231 P. 2D 637 was 1951, wherein it was said, I quote, "It is not required that physicians and surgeons guarantee results, nor that the result be what is desired." Unquote. Thank you very much.
Thank you so much, sir. I request all the dignitaries to take their seats in the audience, please. I would now request Honorable Dr. S.M. Kantikar, Member, National Consumer Disputes Redressal Commission, New Delhi, to please express his thoughts on the topic, how to avoid medical negligence.
Correct.
Good evening, everyone. Distinguished guests, the chairman of this organization, our Honorable President of National Commission, Honorable President of Maharashtra State Commission, the intellectuals, doctors, lawyers, and my colleague. I'm happy to come over to Maharashtra after a long time. And being Maharashtrian, I'm very happy to meet my friend, Dr. Shinde, who is also from VM Medical College, and few of my lawyer friends, Dr. Swami and others. So with this brief, let us start. The previous speakers, the talk of Honorable President of National and State Commission, they have elaborately discussed. And their emphasis is on 2 aspects on the doctors. One is negligence and another is unfair trade practice. the concept of unfair practice is coming recently. It was what I feel, it was whether it was unnoticed or what, but it is coming up now and people are recognizing. And as I told, that why more litigation now? It is whether doctors are at fault or whether the community, the patients, they are more aware or the consumer is aware of his right. You know, just Honorable President, our President told our services. Next slide. No, I should operate. Can I operate from here? Show me. Huh? The yes, which key? Yes, yes. This. Ah, okay. Huh? Yes, yes. So now my emphasis will be as a medical professional and having worked in the National Commission for 1 decade now, I am completing. And what I have observed, whether the consumer is more aware or doctors are at fault, I have to analyze and so a lot of judgment, a lot of cases where coming National Commission, you are aware it is the original, revisional and appellate jurisdiction also. So we receive many cases and now I will show the slide how the rising trend of medical negligence is there. So with this, my emphasis will be not to create any panic in the doctors, but my emphasis will be preventive litigation, how doctors shall prevent the litigation. Because once litigation starts, then doing some work that will not help. You will be under duress, stress, and your mind will not be attentive to the other patients also, what I have observed. So my emphasis will be the preventive litigation. Today I will focus how you can avoid the litigation, what precautions you should take. Before that, I would like to share what are the patient's right. I think you might have seen the slide. No need to go into the detail. So everyone told, few speakers just told about medical records. The Medical Council of India 1.3 regulation. Now in NMC it may be changed, but medical records, it is the right of the patient to obtain medical records from the hospital. Remember, if you are a practicing doctors and if the patient asks, patient or his near relative asks in writing, remember in writing, then you are bound to give the record within 72 hours. If not, what will happen? If not, the patient or the party will go to approach the regulatory body and may take action under professional misconduct. So that amounts to professional misconduct. So remember, I want to ask the gathering, whose property the medical record is, whose property, either patients or doctors. There are many times I ask in the conferences, but doctors say it is to prevent the patient will lose his documents and others. No. What I will suggest, why you take the headache to preserve the record? While at the time of discharge, you hand over the record, take the acknowledgement. Because remember, the litigation, the cause of the time frame, the limitation is 2 years. A patient can file the complaint within 2 years, up to 2 years. So the hanging sword is on you. When somebody will go to court, you don't know. And if you are busy, if you are out of country, if you are not traceable, then who will give the record? So better it is the property, because you are charging for that. You are charging the patient, you are giving services to the patient. All the records are his. For precaution, either you give original or you give Xerox, but with the endorsement, acknowledgement. Then we will discuss the informed consent, and these are the patient's rights. Yes, this one. Now just our Lordship told there is a misconception. Remember the doctors fraternity, first misconception, not misconception, when after VP Shanta's judgment in 1995, medical services were brought under Consumer Protection Act. There, that time, lot of protest from our association, including IMA also. And in that case, Honorable Supreme Court decided the medical services are the services as defined under Consumer Protection Act. Now, recently, again, there was a celebration or confusion amongst the doctors that in the 2019 Act, it is a new Act, and our medical services are excluded. Remember, my friends, these are not excluded. Just Honorable President also told, he has referred the Honorable Supreme Court case. I will also repeat that in the Bombay High Court, there was a PIL and that was challenged. That decision was challenged before the Honorable Supreme Court. And Honorable Supreme Court, Justice D.Y. Chandrachud, held that definition of service is wide enough under the Act. If the Parliament, when you will not be liable, if the Parliament wanted to exclude, they would have said expressly. So remember, in this Act, it is not expressly deleted, the medical services. So, and moreover, there is a judgment of larger bench, VP Shanta's case, three judges bench judgment. So unless the Supreme Court decides or take a view, any other view on with the larger bench, then only it is possible. And in this case, Honorable Supreme Court penalized the appellant with 50,000 and dismissed the appeal. So let us come to the subject. What is the doctor? How doctor is liable? Doctor is liable under many channels. Doctor is such a person, he is entangled with many acts. From the Municipal Act to all income tax, every act. We are as a human being, but the special in the liability of medical negligence, how he is liable, his liability will be under Criminal Act, then criminal liability, civil liability. Under civil liability, there are again two channels. One is contractual, second is CPA, means Consumer Protection Act. Now 86 is not there, now it is 2019. And next is PRB, it is professional regulatory bodies, either MCI, DCI, whatever it is, or Ayurveda Council or so. So now, what is medical negligence? First, we have to understand what is medical negligence. We say negligence, but what is the definition? Very simple. It is an act of omission or act of commission. What is omission? Act of omission, it is what you are supposed to do, but you are not doing that. If you are a surgeon, if you are a physician, if you are a family doctor, family physician, if the patient comes with the chest pain, now what you supposed to do? You are not doing that. You are not referring the patient. If you are a physician, then definitely you have to do ECG or other thing and diagnose. Just simply giving the medicines for gastritis and go ahead. This is the act of omission. You have not done what you are supposed to do. Then the act of commission, what suppose not to do, but you are doing that. Both are interchangeable, both are mixable also. So understand this, and I have given few examples, so I don't want to waste the time. I will circulate this slide also among the participants. So remember two words, act of omission and act of commission. If you have done anything in this, then try thinking whether I am liable. Next is, what are the types of medical errors? So medical errors, I have given example also. The diagnosis or evaluation error. Then the medical decision making. Yes, whether I can treat this patient. You remember the Honorable Supreme Court in Lakshman Balakrishna Joshi's case. I think it is a very old case, and it has defined what are the duties of the doctor. Duty means what is the duty, whether I should undertake. Shall I examine the patient? Is it my duty? If yes, then which treatment I should give? And if you decide both, then how I should proceed? Honorable Supreme Court in L.B. Joshi's case, you can find in the our journals, Lakshman Balkrishna Joshi versus it is the Godbole's case. Then decision making is very important. Then the treatment, error in the treatment. You all are aware something goes wrong. But remember, if the treatment goes wrong, every treatment which goes wrong is not necessarily a negligence. What happens? Why doctors are afraid of? I have committed, somebody has filed a case against me. This phobia is there. And I have not committed anything, but the case is being filed in the Consumer Commission. So remember, don't be afraid. Law is there. Something has happened. Now you have to defend. Compare with the other things. If you have not paid the taxes, the notice will come. Like that, you have received the notice, you have to reply. Don't keep the notice in your drawer or just go on thinking or go in the tension. Take the assistance of advocates or someone or medical legal expert and frame your reply. Analyze where I have gone wrong, whether I have done anything. Then you will get the answer and then how to defend it. Then the medication, incorrect dosage. Yes, many times this happens. Insulin dosage or cancer treatment or this chemotherapy dosage, they have to calculate, titrate. These are the things. So who is responsible for all this? The doctor is responsible. The master of ship is responsible. You can't say, I told the sister she has prepared the dose like this and I have injected. No. Finally, the liability, the master is responsible. It is the doctor who is heading the unit, he is responsible. Then the inadequate supervision, yes, just I told, doctor is liable. Then the faulty communication. We all spoke just now, faulty communication, because now doctors are not talking much more. Just commissioner told the example, the family doctor in his childhood or so, that time it was very good communication. Doctor will just put his hand on the body of the patient and patient will be cured. What happened? What are the symptoms? So now the communication has gone. What we observe or we have to accept. And I also being a doctor, I also face, no doctor will talk. He will give the prescription, go this, bring this, do this investigations, finish. He is the illiterate patient, how he will understand? Okay, go and take these medicines. The pharmacist will give different tablets and he will go and consume the tablets and suffer hypoglycemic coma also. So talk to the patient at least, because the doctor-patient relationship is the most important thing to avoid the most of the litigations. Then the procedural complications, okay. Yes. Now remember these 4 Ds. This is very vital. If you are afraid of, or if you are hit by the case of medical negligence, notice received, remember these 4 Ds, because the complainant or the patient or complainant has to prove his case in the medical negligence cases. What are these D? Just I told the example of L.B. Joshi's case. So 4 Ds are: complainant has to prove the doctor has the duty towards the patient. Then there was a deficiency in the duty. Yes, he has duty to examine the patient. He has not examined. Then that amounts to deficiency. Suppose if he is a gynecologist and orthopedic patient comes and he will ask, do my plastering. He will not do plastering. Then he will suffer, patient will suffer malunion or some infection or amputation, whatever it is. Whether that person, that patient can file a complaint, he may file the complaint. Now he has to establish whether this doctor has a duty to treat me. When gynecologist, he has no duty unless it was emergency. If definitely emergency, then definitely he has to treat or refer the patient or do the first aid. So he has to establish the 4Ds, duty, then deficiency, then that deficiency should result direct injury. Many times we have received the complaints, placebo therapy. Doctor will give some placebo tablets and the complainant will file he has given unnecessarily more medicines to earn money, and because of that I suffered this and that. Whether these placebos, there was a duty he has given, because placebos are to satisfy also. Placebos are given along with the other medicines. So there was duty. What is deficiency there? There is no deficiency also. Whether that, suppose if we think the tablets he has given more and or the patient consumed more, whether that directly injured that patient, no, then there is no liability. Remember, analyze your case, whether 4Ds are fit in my case. When there is no duty, my duty, I am not liable. So some reasons, just I told the errors, it is again some repetition. Now, how to avoid diagnostic errors? This is also, I have chosen as being a pathologist, I have chosen one slide, how to avoid diagnostic error. The pathologists, few pathologists are also there, or they are running, doctors are running laboratories also. Or if the doctor is examining the patient also, don't jump directly on the diagnosis, because diagnosis is such a thing, it will create some psychological impact on the patient. And that will trickle, because today the Google is there, patient will come and Googled all the things and he will ask you, no doctor, it is there and this and that, and then you will be in trouble. Your duty is record what patient says. Don't record beyond that. Patient may ask 100 questions, but you restrict, it is your duty how to tackle, how diplomatic you should be. It is amongst you. Nobody should teach you how to deal the patient. Then the avoid first impression, then the document complete differential diagnosis and evaluation. Then obtain appropriate consultation also if this is related to pathologist. If pathologist is under confusion, he can discuss with the consultants and arrive for the diagnosis. Remember, taking second opinion is not a negligence. Again, many times the allegations which we see, he sent my patient to this hospital for the second opinion, or so that doctor was incompetent. So patient suffered complications. No, referring the patient is not negligence, but the referring the patient not at a proper time is a negligence. So remember. Yes, how to prevent again. Remember these 6 things. Practice effective communication. Yes, that is very important. Establish good relationship. It is doctor and patient relationship. Now I want to add, I think I have missed that. You have to put doctor to doctor also. Remember, doctor to doctor also. You have to put good relation between doctor to doctor also. Because this is known as sponsored litigation. Remember, what is sponsored litigation? I am a doctor, I will treat one patient. The patient will go to other doctor, he will say, "Arey, what he has done? This should have been this," and if you have no good relation, doctor-patient relationship is that is one area. Second is doctor to doctor relation is also important. This is the thing. Just आइडिया नहीं कहीं स्लाइड स्लाइड नहीं स्लाइड शो येत नाही पीपीटी पीडीएफ पाहिजे पीडीएफ कशाला पीपीटी पाहिजे होतं पीडीएफ दिली कोणी दिली पीपीटी PPT आली पण या कंटेस्टला PPT घेतली नाही त्यात इफेक्ट पण होता. PPT आहे ना? नाही PPT नाही ठीक आहे आता चला ठीक ओके. तिथे आली नाही मी पाठवलं त्यांना पाठवलं सूर्यवंशींना बघा येते. Yes, remember this. Be thorough before, during, and after appointments. Okay, you are calling the patient. You recall his previous record also, and go accordingly. Don't just listen the patient. What? Because if he has not brought the previous record, then definitely, if you have electronic record, retrieve the record and then go ahead. Because some information, maybe patients, I'm not telling illiteracy, patient's ignorance, he may miss something and to tell you. Then understand the informed consent. I will come, what is the brand, I will come to that. And keep complete record and documents. What is safety? The sense of error, you should know what, you should sense the error where it has happened, act to prevent it. Then the follow safety guidelines also, because now it is SOPs, standard operating procedures. If you are running hospital, there should be standard operating procedures from the front office. Because most of the mistakes where the litigation starts from the front office, the billing section, where the spark comes, the billing. Because patient will ask the bill clarification, there is double billing, unwanted medicines are added. So that will create some spark. Then follow the safety, then inquire in the accident or deaths. If you are running hospital, if there is a death, there should be some committee or some some faculty should take care and come to the conclusion why did this death happen, and you can give the report to the patient also. Take the necessary remedial measures also. And your doctor's responsibility is more in this case, because he has to, if there is a death, then he has to certify the cause of death also. Then the disclosure, how to prevent, disclose. There should be open disclosure. Yes, this thing happened. There are chances that litigation, if the patient or the party, if they understand, the chances of litigations are less, but not 100%. Then honest disclosure should be the compassionate conversation should be there. It should be as soon as possible. Whether the apology will solve the problems? No, apology sometimes may or may not solve the problems. And assure the patient, suppose anything goes wrong, assure the patient, I will take the follow-up. You can come for the physiotherapy and other thing, and we'll take care. This soft words, soft communication definitely will solve the many problems. Yes, this is another thing. Disclosure does not always absolve the doctor from legal proceeding. Just I told, whether the disclosure, sometimes it may help the doctor, but not always. The words, how will you spell the words? I am sorry for what happened to you. But if you mention in that, I am sorry for what I did to you, there is a lot of difference. How will you come with that? Then the medical record. The medical record is again a confusing issue. First is whose record it is. I have told with my knowledge, the record is of the patient. Don't keep with you and don't take the headache to preserve the records of the patient unnecessarily, because it consumes a lot of space, a lot of time, and then a lot of botheration later on. So the just it is you heard the section 1.3, not regulation 1.3 of MCI says you have to maintain 3 years and if required, deliver within 72 hours. Now, which records are very important? We are talking about records. What are the records now? One is case sheet. Many times question comes OPD record and IPD record. Okay, no doubt. Many doctors, and it is a convention now. OPD records, doctor will hand over the records to the patient. So it is the onus is on the patient to prove or bring that record to prove his case. If he say no, he has given this and that, no. If he miss that OPD slip, he can't succeed the case. Yeah, the doctor has good ground for defense. Then for the IPD records, the chronology is very important. Many times we observe the date of admission is different and date of discharge is different. There is a lot of difference. The discharge is previous and admission is later on. So if such record, okay, we can say in hurry we have made that. But that reflects how much you are careful towards the patient, because it will carry the things to decide the judge, because there are multiple. The rounds are taken at one place, you will write 6 a.m. At another place, you will write 10 p.m., 6 a.m. and 10 p.m. and how to correlate. Date will match. So the flow should be there. Just check the record. Then these are very important records, the referral note, discharge note, then confidential note. Correcting of the medical record is another important issue, that many times this is also one offense, criminal offense also. Tampering of the record is criminal offense. So don't do that if you have done wrong, because limitation I told it is 2 years. Patient will come after 1 year and you will suddenly flash, "Arey, I have not written this and I will write." Or my resident who was that time, I will bring her. But forensic experts may diagnose this is the tampered record, and that straightway proves the negligence. Unnecessarily don't go in that. Then how to correct the record? You scratch the record and write this. Because of this, I am correcting this record, and it should be in the different ink. Don't scribble. Just put a line and write what happened, or left side or right side of the paper, and with the date and with one witness also. That may help you. If it is a blunder, then blunder. Then the tampering and destruction. Yes, destruction of the record is another question. Many times they ask how to destroy our records, huge records. So give one paper publication. From so and so date, we are destroying our medical records, inpatient records. If anybody want to claim, then just come before so and so date, then you destroy the records. That will save you. Yes, then the consent. Now what we see in our commission, general consent we see. The doctor they take general consent. It is a wrong concept. What is informed consent? You have to inform each and everything. Informed consent is valid consent in the law. Informed consent is discussed by Honorable Supreme Court in the Samira Kohli's case also. Then later on, just Lordship told, the evolution of consent took place. Now, the latest judgment of Montgomery judgment, which was in 2015 by UK court, they have given. You can, if you have opportunity, download the Montgomery judgment and read. What is the disclosure? You have to disclose, the doctor has to disclose all. Then the next is consent should be very procedure specific. It should not be generalized consent. Your hospital, if you are taking name, age, sex, and other, and write the operation name and just take a signature, no. If you are doing fracture surgery, then write the complications. Patient may develop the embolism. There may be malunion or whatever it is, complication, hemorrhage. If you are doing seizure, write about amniotic fluid embolism. How you say the doctor has explained me everything and take the signature. This is not a valid consent. So I'll finish. I think I'll skip some slide. What is how your record should be? The appearance should be clear. It is neat. The handwritten note should be in the blue ink, preferably. Write the allergies also if the patient had allergies. Yes, I told this. Referring the patient is not a negligence. This is one area that res ipsa loquitur. What is it? Res ipsa loquitur. The things speak on itself. There is no need to prove the negligence of the doctor. See, this picture, this is the X-ray, the seizure is in the pelvic cavity. Whether anything is needed to prove this case. The swab operation, after operation swab will be kept, patient will develop peritonitis or septicemia and ultrasound will detect the swab or gauze fish. So there is no need. The things will be or doing operation on the wrong limb. Famous case, you may be remembering that the actress, I'm not remembering her, Sridevi's mother's brain surgery. They have operated wrong brain surgery. It happened in US also. So there is no need to prove the wrong you have committed. This is another eggshell skull rule. This I have taken some different slide. Remember what happens? No, that doctor has committed something wrong and the patient approached me and I have treated and I have not done wrong. No. This eggshell skull rule applies. Whatever wrong the patient carries with him, for that also you are liable. This is the eggshell skull rule. Yes, just we spoke. Dr. Pravin Suryawanshi also told 3,000 cases filed. Yes, definitely that study is correct. And this was my study. It was, I have taken one study of 1 decade, almost 7 to 8 years, and see the graph. There is a rising trend of medical negligence cases being filed throughout the country. So these are the few judgments I would like to quote. I am circulating this slide. You can click on the link. You will get the judgment. This PDF will be, I request the organizers to circulate this PDF. Let anybody want, they can click this link and they can read the full judgment. These are the latest. I have discussed the IMA and Samira Kohli also on the consent. V. Krishan Rao, it is on the expert opinion. There are many. The recent judgment, just Lordship also mentioned the Bombay Hospital and Asha Jaiswal, this Chandrani case. These are very good judgments. You will get the knowledge. So I think my time is, I have taken much more time. It is time to end now. So my friends, remember, try to avoid litigation. Solve the litigation at the point of generation. Need for preventive litigation. We need that because once happens, because prevention is better. Avoid the litigation. Ignorance of law is not acceptable. And ignorance of law, I will add another thing. I am busy. The doctor's main grouse is I am busy. We are very busy. That is not acceptable in the law. Then medical record is very important issue. And in that, informed consent is most vital. So thank you very much. This is our commission. So thank you, the organizers who gave me this opportunity. I thank the chairman who was very courteous. We have visited the institute, very nice hospitality, and thank you, Dr. Shinde, R.M. Shinde. Thank you, Bora sir. He is the instrumental to organize this organization, this meeting. So thank you, my colleague from the different district commission, president, members, and the advocates and the junior doctors. Thank you. Any questions? I'll be happy. I will be gaining more knowledge from your questions. Yes. Okay. Thank you.
Thank you so much, sir. Our next speaker is Advocate Dr. Gopinath N. Shenoy, sir. He is an advocate who specializes in medical law and is also senior medico-legal consultant who appears for the doctors and the hospitals in the Supreme Court, High Court, civil and criminal courts, consumer courts, and the medical councils all over India. He has been identified to be one of the India's 12 great personalities to have influenced medical practice in India today by a survey conducted by magazine Future Medicine. He studied law and passed his LLB and LLM with a first class first, bagging all 6 gold medals and scholarships in both the exams. For his thesis in consumer laws, the University of Bombay awarded him a PhD. He is postgraduate examiner in law, LLM, and PhD, Bombay University. He was a member of the Consumer Forum Mumbai, Government of Maharashtra. He was well known to be an honest and a very balanced judge. He is a prolific writer on medical law, and his writings have been quoted verbatim along with his name by the Chief Justice of India, Justice Lahoti, in his judgment. He also passed MD, DGO, DFP, and FCPS with a first class, first, and gold medals in each of the exams. I now invite him for his next speech on the topic Supreme Court's 11 guidelines to be followed whilst deciding a case in medical negligence. Thank you.
Ladies and gentlemen, a very good evening. I think first and foremost, my bounden duty to thank all the organizers for having invited me over here. Thank you very much, sir. Now, to start with, I would say it's a great privilege for me. Why a great privilege? Because today I've got addressing such a beautiful crowd. I have in front of me Justice Agarwal, I have in front of me Justice Taude, I have in front of me all the great personalities, and above all, I have in front of me Chairman Honorable Shri Kadam. It's lovely. Why I feel this is a very beautiful gathering is because there are different people from different sides. For example, there are judges, there are advocates, there are doctors who are practicing, and there are postgraduate students. So when I address you all, the address has got to be in such a way that I'm able to make all of you all understand what I'm saying. Otherwise, if I speak at the level of the doctors, the advocates will not understand. So let us come to a place where we can make both the fraternities come together, and then you will be able to appreciate what those exact 11 guidelines are that the Supreme Court has laid down to be considered whilst deciding a case of medical negligence. So let's start from the very beginning, from the ABCs. So I presume this is something I'm going to give to the students who are postgraduates in medicine. This is for you all. See, law can be classified in various ways. The simplest way in which a law can be classified is law can be something known as a civil law, and the law can be something known as a criminal law. What is the basic difference between the two? The basic difference is the end result of criminal litigation is going to be imprisonment of the wrongdoer. But when it comes to civil, the end result is going to be payment of compensation by the wrongdoer to the aggrieved person. A doctor is frightened of which kind of law? Civil law or criminal law? Every doctor is worried about criminal law. The question is why? It is not because you are going to go behind bars. No, it is not so. We are worried about the criminal law is because if the criminal authority indicts you and punishes you even for one day, then the medical council all by itself suo motu can deregister you, as a result of which you will never be able to practice. So we are worried about the criminal law is because of that. If at all you are indicted by the criminal courts and imprisoned even for one day, that is till the rising of the court you are imprisoned. If at all it is done, then you are gone. So we are worried. So that is one way. There's another way of identifying or classifying law. And the second way is even more interesting, and that is what we are going to speak on today. The second way is law can be something known as a statutory law. And on the other side, law can be something known as a judge-made law. Now, what do you mean by a statutory law? Statutory law is that law that is enacted by the parliament at the center or by the state at the state level. For example, the Consumer Protection Act is a law that becomes sort of a binding precedent, which all lower courts are duty bound to follow. See, when I speak like this, To the non-legal crowd, it becomes a little difficult to understand. So I'll elaborate, especially for the students who are sitting behind. See, whether the doctors came within the ambit of the CP or not was a big gray area. Some courts felt we came. Some courts felt the doctors didn't come. Finally, the Supreme Court, in a very beautiful judgment by the name of IMA versus VP Shanta, laid down the law. Depends upon the facts and circumstances of each case, and therefore it cannot be codified. So the law of medical negligence is a pure judge-made law. It is a law based on precedents, and therefore, to understand the law of medical negligence, what must you understand? You must understand case laws, correct? It's as simple as that. Law of medical negligence is based on judgments, and therefore there is a genesis of every case law. Every case law, there's a story behind it, there's a history behind it, and based on that history, that particular law is generated. So you must understand the case laws, and that exactly is what I'm going to do today. I'm going to give you a very beautiful decision by the Supreme Court, a case law that was decided by the Supreme Court that has laid down the law as far as medical negligence is concerned, and that has given express directions to all the judicial authorities as to whenever a case of medical negligence comes before them, what is it that they must look into? And that is exactly what I'm going to tell you. Now, I'm addressing the advocates also. So I'm going to go a little into the medical aspects of the things, and I'll be a little more elaborate because my advocate friends, my advocate colleagues must also understand, and they must be with me. Otherwise, they will never be able to get that flavor of those 11 points that the Supreme Court has laid down. Now, this is that famous judgment, Kusumlata judgment, Batra Hospital. It's also known as the Batra Hospital judgment. I'll give you a small history as to what happened in this case. And subsequent to that, what are the allegations raised? And subsequent to that, what did the Supreme Court say with respect to every allegation? And that is the law that has been laid down. So what happened was, in Batra Hospital case, in Kusumlata case, the husband of Kusumlata Sharma was a very obese man. He was a very hefty person. And he had lots of problems. He couldn't walk. He had breathlessness. So he got himself investigated. So when he got himself investigated, he entered Batra Hospital and they investigated him and they did a CT scan. And on CT scan, they found a tumor. Where was this tumor? This tumor was on a gland known as an adrenal gland, which is above the kidney. Now, we all have two kidneys, left, right, and the kidneys are placed behind. And on top of the kidney, there is a small gland, which is known as an adrenal gland. And in this adrenal gland, there was a tumor that was identified. Now, when they did the CT scan, they also identified another thing. And that other thing that they identified was this tumor was well encapsulated. For the advocate friends, when I say well encapsulated, it is a sign that this particular tumor is not a cancerous tumor. Because clinically, we come to certain conclusions. Sign is usually seen in non-cancerous growths. They said yes. And it was agreed that the patient was to be operated. The patient was taken up for surgery. A good oncosurgeon, a cancer surgeon, operated upon the patient. Now, the adrenal gland is just above the kidney, and that position is very strategic in the sense that approach to that position becomes many a times very difficult, especially if at all there is cancer. So there are two ways in which this particular gland could be removed. The first one was the anterior approach. You open the stomach from front, go inside. He went to the adrenal, removed that tumor. And when he did so, patient was very obese. Just imagine, there are certain problems in every patient. What he did was, there was an accidental nick on the tail of the pancreas. What is this pancreas for the advocate friends of mine? Pancreas is an organ that secretes insulin. Pancreatic is an organ that secretes a juice known as pancreatic juice. The importance of pancreatic juice is that it is digestive. You take a drop of pancreatic juice and you put it into the abdomen, that juice will digest that particular part of the abdomen. It has got when things go wrong, everything goes wrong. Remember this. That is sort of a dictum that is there. Because I told you that the tumor was removed and the tumor was sent for histopathology. You know what happened? the histopathology report came. And that histopathology report said that this particular tumor is not benign, but it is cancerous. So once again, another problem took place. So they said when the patient died, a lot of allegations were raised. Now the first allegation that was raised, I'm telling you how the law is settled now. Just imagine how position. So now, how did the doctors handle this particular proposition? The doctor said, 100% there is no negligence. I may have erred in my diagnosis. To err is human, it is, but every error in diagnosis is not a negligent diagnosis, especially when the error takes place after due application of mind. That is the law. The law says that even if I err, it doesn't matter. But the error must take place after due application of mind. And therefore, in medical parlance, what does it mean by due application of mind is the question. Correct? This is something that the medicos must understand. Due application of mind means you have got to take the history of the patient, you've got to examine the patient, you've got to undertake the necessary investigations, and after this, you've got to come to a reasoned conclusion to whatever your diagnosis is. And whenever you come to a conclusion in this particular manner, your diagnosis will always fall within the ambit of the differential diagnosis. This is very clear. And that is why when you're doing your third MBBS, your MS, MD, they always lay a lot of stress on what can be the differential diagnosis. It's so important. When we were in third MBBS or when we were in MD, we used to just rattamaro that differential diagnosis. But the real importance is now when you enter into clinical practice. So applying these 4 rules, the doctors told the court, we have taken the history, a proper history, we have examined the patient, we have got the necessary investigations done. And based on this, we have come to a reasoned conclusion that the tumor was benign, was not malignant. And if at all it does turn to be malignant, it is a pure error of diagnosis. And whenever there's a pure error of diagnosis based on due application of mind, such an error of diagnosis is not negligence, and there is no amount compensation due and payable for this particular proposition. So that is the law. For those who want to take home, error of diagnosis is not. But there has got to be a due application. Without due application of mind, if at all you give any kind of a diagnosis, that 100% is negligence in the eyes of law. So it has to be. Now the second allegation that was raised was you operated the patient by the anterior route. And because you operated the patient by the anterior route, the pancreas got damaged. And because the pancreas got damaged, there was a mess post-operatively, and my patient finally died. The widow said, had you approached this particular tumor from the posterior approach, there was no question of damaging the pancreas, and my husband would have been alive today. This approach of yours was wrong, and therefore pay me compensation. This was the proposition. Are you understanding what I'm saying? It's very simple. Now, what did the court say? The courts were very clear. The court said that whenever any surgical procedure or any treatment procedure can be undertaken in more than one ways, and if at all the doctor chooses one methodology to the exclusion of the other, and if at all there is a problem, that problem does not really mean negligence, because it is something known as the discretionary power that the doctor has as to which approach to adopt. And as long as the approach that he has adopted is one of the standard operating procedures for that particular case, no compensation becomes due and payable. This is that very famous law, which goes by the name of Boehm's law. I'll tell you, I think most of intensity of fits, what the doctors give is they give something known as a muscle relaxant, which when given paralyzes the muscles, as a result of which when an ECT is given, the intensity of fits is very mild. So there are no problems. That is the meaning of muscle relaxants. So at that point of time in England, 2 ways ECTs were given. One school believed, one school did not believe. And you know what Bolam's psychiatrist believed in? Bolam's psychiatrist believed in not giving muscle relaxants because he was of the opinion that if the convulsions are violent, it will help the patient in a better way, except at school. Bolam was given a ECT without a muscle relaxant. He had severe convulsions, as a result of which he developed a fracture of the bone. The convulsions were so heavy. The fracture was identified, not that it was not identified. And subsequently to identification, the fracture was treated. And after that, the matter went to the courts there. And in the courts, this particular decision was given by none other than Lord Justice Denning, who is supposed to be the master or the father of medical law. He said that if at all you accept the teachings of one particular school and treat the patient according to that particular school, and if at all there is some calamity, some problem, that problem should never be linked to your choice, as long as your choice is one of the accepted choices by the fraternity. So beautiful it is. So that Bolam's law is very much there over here also. Here also what happened? The doctors told the court that this particular tumor can be approached by two methodologies. One is the anterior approach and one is the posterior approach. And I believed in doing the anterior approach. And the doctors also gave their reasons as to why they believed anterior approach was better, because in an elderly patient, whatever may be the clinical diagnosis, there is a possibility of malignancy. And when you open the patient from front, you are able to identify so many other organs inside the abdomen. And you can find out whether the other side adrenal tumor also has got a problem. So anterior approach, according to me, was very good. And how did they prove this? By keeping standard textbooks before the courts. You know, standard textbooks is something which is really comes to your rescue. You can really choose it. And when standard textbooks are kept in front of the courts, by and large, the courts accept it because textbooks are considered to be the gold standards. Why is it the gold standard? Because I learn from the textbooks. When I practice tomorrow in the fraternity, I practice the teachings as mentioned in the textbooks. And lastly, when I have to teach my juniors, what do? I teach them what is written in the textbooks. So remember, textbooks are always the gold standards, and they always come to your rescue when a particular proposition needs to be explained to the court. I believe in it, and I've done it, and it also, it did not. The court said, then how do you explain the tear in the pancreas? Correct, na? There was a nick in the tail of the pancreas. As a result of it, the pancreatic juice started leaking. As a result of it, there was a fistula, there was a fecal fistula. Everything happened and the patient died. The cause was damage to the pancreas. So the question was, how do you legally explain this particular proposition? And the answer to this question is, in law, there is something known as medical accidents that can take place. In spite of taking all the care and caution, is there a guarantee that a particular kind of an accident cannot take place at the hands of the doctor? It is impossible. Because even if you take all the care, certain situations are such that can, and here the situation was, the patient was very obese. And when the patient was very obese, and when you have got to retract, when you go to pull the abdomen to one side, that nick took place. But then it was identified and it was sutured in time. Therefore, a medical accident in the eyes of law is not negligence. Now the question is, in the courts of law, the patients always say what happened was negligence, and the doctors always take the stand that this is a medical accident. And differentiating the two is a very, very fine job, which only good advocates can do, because the compartment is paper thin. Now, how do you identify an accident is the question. Now, the answer is when the right thing is done by the right person in the right place by the right technique with the requisite care and caution. If something untoward happens, that untoward happening in the eyes of law is a pure medical accident. I'm repeating, I'm being recorded, but let it go. The right thing done by the right person in the right place by the right technique with the requisite care and caution. If these 5 points are in the favor of the doctor, the end result, whatever it may be, end result in the eyes of law is a pure accident. Now let us apply this theorem, this particular theory, let us apply to this particular case. Now, removal of the adrenal tumor, which is a secreting adrenal tumor, a problematic adrenal tumor, was the right thing to do. It was done by the right person. The person was an oncosurgeon, an abdominal surgeon, who did it, the right person, in the right place. It was done in a tertiary care big hospital by the right technique. Opening the patient by the anterior approach was the right technique as mentioned in the textbooks, with all the care and caution, in the sense that the patient was properly investigated and whatever was done, like the removal of the spleen was required, everything was done the way it was really required to be done. And therefore the end result, the fistula that took place, the pancreatic leak that took place, the pancreatic damage that took place, that in the eyes of law is a... you are giving me some time, no? Huh? Because I think 45 minutes. We have time. Huh? Please stop me. Huh? So that thing is a medical accident. And whenever a medical accident is proved in this particular manner, by and large, courts accept it. And therefore, if at all the advocate is able to prove what happened was a pure medical accident, then it is not actionable. This is what the law is. And that is what the Supreme Courts have been saying in this particular case. Now, subsequently, there was another allegation that came up. And the next allegation that came up was, you removed my spleen, which was on the right side, and you had not taken consent for removal of the spleen. Now, this consent is one thing that is always there, but then it's a good thing it is there. It is a good thing that is there. So this particular issue was also decided in this particular case because you had to remove the spleen to approach the pancreas, to approach the adrenal gland. Otherwise, approaching the adrenal gland by the anterior approach was practically impossible. And spleen was not that important organ that it cannot be sacrificed, and it was sacrificed. Ideally, yes, consent should have been taken, because when you decide the case to be operated from the anterior approach, removal of the pancreas is going to come in removal of the spleen is going to come into the question, especially when the tumor is just sitting bang behind the spleen. So, but here the question is, now this is one thing where I have got my own views. And today, whatever I'm going to say on consent is my view. And let me put it across, because I've got a lot of nice people in front of me. They will correct me if I'm wrong, but let's see. The law of consent today, as it is applicable to us in India today, has been laid down in the Samira Kohli's case. There is no doubt about it. Samira Kohli's case is a case that is a dedicated case on consent. What is written there is dedicated. And in Samira Kohli's case, Samira Kohli, the Supreme Court, a 3-judge bench, identifies informed consent as against a real consent. There are two concepts, informed consent and the real consent on the other side. Informed consent is a consent that is a concept that is laid down by the American courts in the Canterbury's case. And real consent is the consent that is laid down by the British courts in the Sideways case. His Lordship just now explained these things. Now, what is the basic difference between the Canterbury's consent and the Sideways consent? The basic difference is, in the Canterbury's case, that is the US case, the US courts have been saying that when you take consent, you've got to tell the patient everything possible that can happen to the patient. Like, you can tell the patient, I take you on the operation table, I'll give you anesthesia, you might just not come out of anesthesia, because that possibility is there. You have to tell the patient, I give you anesthesia, you might die on the table, because that possibility is there. Everything must be told. And only when the patient comes to know everything, he is able to make an informed choice, correct? This is Canterbury, US, informed consent. As against this, in the UK, the concept is something totally different. UK believes in the real consent. And in the real consent, the UK courts were, I'm using the word were, not are. UK courts believed that the doctor needs to tell the patient whatever he asks without fear or favor. If the patient says, doctor, can I die? Yes, you can die. But if at all he is not asked, how much should the doctor disclose to the patient is the question. And the UK court said that anything that is under 10% need not be disclosed, and whatever is above 10% has got to be disclosed. And this is real consent. So it is doctor-centric. The doctor tells the patient what the patient wants to know. But anything above 10% needs to be told. Under 10% need not be told. Now, in Samira Kohli versus Dr. Prabha Manjanda, para 33, if I'm not forgetting, it is very clearly mentioned. Both these concepts. the Canterbury's principle, American concept, and the sideways principle, the UK concept. And the Supreme Court, 3-judge bench has laid down that the Indian society today is not geared up to that extent so as to accept everything that is told by the patient. Many a times what happens is, if the patient is told, you might just not wake up, because we people are not educated the way the American society is educated. So the Supreme Court literally writes down that the society might become more educated. At that point of time, this particular concept of informed consent should be considered, but not for the present. It very clearly states not for the present. And that is why I am of the opinion that this particular judgment is a Supreme Court order and it is a 3-judge bench opinion. And if at all it needs to be overturned, it has got to be overturned again by the Supreme Court, either by a 3-judge bench or by a 5-judge bench. Definitely not a smaller bench, because the law of precedents are very clear. It has got to be done by an identical bench or a bigger bench. Can the district forum change this particular decision? No, it should not be done, because as per Article 141, whatever the Supreme Court says becomes the law of the land. So in England, sideways ruled for 30 years. You will not believe it. In England, sideways came into existence in 1985, if I'm not mistaken, and it ruled for 30 years. And it is after 30 years that the Montgomery's case came in 215. And Montgomery's case, after 30 years, changed this particular rule. Today in England, informed consent is the rule. But prior to 2015, informed consent was not a rule. The real consent was the rule, even in England. So this is something which keeps on changing. And the way I put it is, if at all there is a particular act which says an informed consent is mandatory, then for all purpose of that act, informed consent must be taken. Everything must be told to the patient. Just imagine a person from the village comes to you and you tell him, I'll give you anesthesia, and you might not just wake up. What is he going to do? He will say, tumse operation पण नको, तुम्ही पण नको. So a surgery that is very much required might be avoided. And this is exactly what the Supreme Court says in Samira Kodi's case. Fine. It was just an occasion that I got to express myself, and that is why I've told you. Now, finally, this particular patient, another allegation that was raised is that you gave me guarantee that I would be all right. Correct? So when the counseling takes place, they always say, and doctors like fools, they always speak positive. They never speak negative. I use the word like fools, because I think this concept now is slowly changing. But doctors are always supportive. And that is how the doctors may have said that don't worry, we will get it out. And it looks to be a benign tumor. It just go in, remove the tumor and come out. But what happened was something totally different. So one of the allegations raised is that you said that I would get all right. You gave guarantee with respect to the end results of your services. Now, what was the law with respect to giving guarantee or warranty with respect to the end results of the services? In this particular judgment, the Supreme Court says very clearly, professionals are not expected to give guarantee or warranty with respect to the end results of your services, correct? That is one of the privileges we have. And when I say professionals, it includes people like me, lawyers. Today I'm a lawyer, correct? Na? So even the lawyers are not expected to give guarantee or warranty with respect to the end results of their services. But what is expected from them is that they should render their services without any shortcomings or without it being substandard. If at all you are able to do that, end result really doesn't matter. And in this case also, the services rendered were very beautifully done, were executed without any shortcomings, without any deficiencies. The end result was a death. And that death also took place because the pancreas got accidentally damaged. The word is accidentally damaged. And the moment the word accident comes in, the whole scenario changes. So with that in the background, the Supreme Court finally in this particular judgment says that we are laying down certain criteria which are to be followed by all courts. And these criteria are laid down in this particular judgment, the last part of it. And this is something I will read very fast because my friend, Dr. Lalit Kapoor is waiting. So I have got to give him, because he's also a lovely speaker and will give you such a lot of material. You'll be so very happy. So he's waiting. So I'll finish this very fast and then I'll call it a day. Of course, I will be always here for the panel discussion. Screen down. Screen down. Bas. Bas. Here, there was another very nice decision given in this particular case. That is, if at all, there is manifestation of an inherent risk with respect to any kind of a treatment, how should the law look at it? See, damage to the pancreas in an obese patient when such an operation is done is an inherent risk with this kind of surgeries. If at all an inherent risk does come up whenever you operate, when a well-documented complication does become manifest when a doctor operates, does that manifestation of an inherent risk, or does that manifestation of a well-documented complication, does it amount to negligence is the question. And in this case, the Supreme Court has decided it. See, this is that case. For those who want the entire title, this is the case. It is recorded, so you can get it subsequently. See, this is what the Supreme Court says when it comes to manifestation of an inherent risk. The Supreme Court says, medical science has conferred great benefits on mankind, but these benefits are attended by considerable risks. Every surgical operation is attended by risks. We cannot take the benefits without taking the risks. Every advancement in technique is also attended by risks. So if at all a risk does happen, if at all a risk does get manifest, that manifestation is ipso facto not negligence. That is what the Supreme Court says. Now this is another small quote that is given, a very nice quote which I very favorite. It is so easy to be wise after the event and condemn as negligence that which is only a misadventure. We ought to be on our guard. We means who? We means who? The judges. The Supreme Court says we ought to be on our guard against it, especially in cases against hospitals and doctors. See how beautifully it is put. Now, this is again the same thing. Then the Supreme Court says in this particular judgment, but we should be doing a disservice to the community at large if we were to impose liability on hospitals and doctors for everything that happens to go wrong. Because I told you, when things start going wrong, everything goes wrong and it becomes a mess. Then you believe, you regret that you ever became a doctor. But then, well, you can't help it. Doctors can't do anything else. In that respect, I'm a little lucky, I should say. Okay, now this is what is negligence. Let's not go into it. It has been done so many times. Negligence, and this is also the third. This is the third rule. See, the Supreme Court says the medical professional is expected to bring a reasonable degree. The word is reasonable degree of skill and knowledge, and must exercise a reasonable degree of care. The word is reasonable. Neither the very highest nor a very low degree of care and competence, judged in the light of the particular circumstances of each case, is what the law requires. So there may be other surgeons who may be better than me. Beautiful. There might be surgeons who are not as good as me. But law doesn't look at that. The law says that if at all the services rendered by you are reasonable, that is enough. A medical practitioner would be liable only where his conduct fell below that of the standards of a reasonably competent practitioner in the field. Once again, the Supreme Court is harping upon these words, reasonable, reasonable, reasonable. Next, in the realms of diagnosis and treatment, there is ample scope of genuine difference of opinion, and one professional doctor is clearly not negligent merely because its conclusion differs from that of another professional doctor. This is error in diagnosis. I may diagnose a particular problem as A, some other doctor might diagnose the problem as B, and some third doctor might diagnose it as C. And I tell you, the third doctor is the luckiest because he has the reports and the thinking of the previous two doctors. So, but then, well, it is the first doctor who gets the burden, absolutely. Let's go ahead. See, this is a very nice quote in this particular, it's a rule that we've got to consider when we are deciding a case of medical negligence. The Supreme Court says, it's something very nice. The medical professional is often called upon to adopt a procedure which involves higher element of risk, but which he honestly believes as providing greater chances of success for the patient than rather than a procedure involving lesser risk but a higher chance of failure. This is very typical. Anterior approach, I have a better exposure inside. I can see everything inside, and if at all I encounter some other problem, I can handle it. But it is difficult. Just because a professional looking into the gravity of the illness has taken a higher element of risk to redeem the patient out of his or her suffering, which did not yield the desired result, may not amount to negligence. See, it's so clear. Medical law is not very difficult. If at all, these guidelines are followed. Negligence cannot be attributed to a doctor so long as he performs his duty with reasonable, once again that word reasonable is there, reasonable skill and competence, merely because the doctor chooses one course of action in preference to another one available. He would not be liable in the course of action chosen by him as chosen by him was acceptable to the medical profession. So anterior approach I chose, it was a professional discretion, and that is one of the accepted approaches, and therefore he is not liable to pay compensation because of his choice of approach. It would not be conducive to the efficiency of the medical profession if no doctor could administer medicines without the halter around his neck. And this is important. Read this. The Supreme Court says, the 9th rule, it is our, once again, our is Supreme Court's. It is our bounden duty and obligation of the civil society. Nowadays, there's a lot of problems in the civil society. Obligation of the civil society to ensure that the medical professionals are not unnecessarily harassed or humiliated so that they can perform their professional duties without fear and apprehension. The 10th one, the medical professional at times also has to be saved from such a class of complainants who use criminal process as a tool for pressurizing the medical professionals, hospitals, particularly private hospitals or clinics, for extracting uncalled for compensation. Such malicious proceedings deserve to be discarded against the medical practitioner. And the last rule is the medical professionals are entitled to get protection so long as they perform their duties with reasonable skill and competence and in the interest of the patient. The interest and the welfare of the patient have to be paramount for medical professionals. With that, ladies and gentlemen, I think I've exhausted the 45 minutes. Thank you very much. I'm always there.
Thank you so much, sir. Our next speaker is Dr. Lalit Kapoor, sir. He has qualified his MBBS from Grant Medical College, Bombay University in 1968. He also qualified MS in General Surgery from Grant Medical College, Bombay University in 1972. Dr. Lalit stood first in Bombay University and was awarded 5 gold medals and a prize for passing the exam with the highest degree of proficiency. He was also awarded the Dr. A.P. Bacha Memorial Gold Medal and Prize, Dr. C.S. Patel Gold Medal in Surgery, and Dr. Mugaonkar Gold Medal. Dr. Lalit sir is specially interested in medico-legal aspects of medical practice, and he is the author of a widely acclaimed book titled Better Safe Than Sorry, Medico-Legal Do's and Don'ts, forward by Justice Radhakrishnan, sitting Bombay HC Judge, released by Mr. Narayana Murthy, Chairman of Infosys, in October 2005. I would like to request Dr. Lalit Kapoor sir to present his speech. Thank you.
Good evening, friends. It is indeed a great privilege and a great honor to be invited by MGM Hospital, Aurangabad, for this memorable function, memorable program with such tall speakers who have really enlightened us. In fact, the subject on which I am going to speak is a bit different from the earlier speakers. You had a lot of knowledge about law, the legal processes. They were beautifully represented. Honorable Justice Agarwal, Honorable Kantikar sir, and the others gave a wonderful rendition of the legal positions. So I think when you leave your knowledge of law would have increased manifold. And but I'm not going to talk about the legal aspects. I'm going to talk on the impact that the Consumer Protection Act has had on patients, doctors, and the healthcare system. What are the pros and cons? What are the pluses and minuses? No person or no system is all good or all bad. Somebody's all had good points and bad points. Similarly, every system has something that is good and something that is bad. And therefore, I'm going to analyze what is good about the CPA which got applied to doctors and what is not so good. Now, I'll go through these slides very quickly because you are already aware of these things, that how the CPA came into existence. In April 85, the United Nations passed guidelines for all its member states, including India, for taking measures for consumer protection. Following this, the central government, under the Prime Ministership of Mr. Rajiv Gandhi at that time, enacted the CPA 1986 by an act of parliament. It was a great victory for consumerism. Now, what is consumerism? What is a consumer? A consumer is a person who purchases goods and services for personal use. And what is consumerism? Consumerism is protection of the interest of the consumers. As simple as that. Now, in the pre-CPA era, buyers had to follow the rule. In Latin, it's called caveat emptor, means let the buyer beware. The buyer should be beware. Let the buyer be careful what he is buying. But this changed into caveat venditor, which means let the seller beware. So today, it is the seller who has to be beware and take care of the interest of the consumer. Thus, a seller's market became a buyer's market. Now, is consumerism good or is it not good? All of us sitting here, all of us are consumers. We are consumers from the time we are born to the time we die. We are consumers. How can something that is in the interest of consumers be bad? Therefore, consumerism is good. Consumer Act is not bad. But let us see a balanced thing as far as the medical profession is concerned, what good it has done and what is something that is not desirable. Now, this again has already been mentioned, so I'll not waste too much time. After 1986, the Consumer Act was passed in 1986. Many patients all across the country filed cases against doctors, hospitals for compensation. But in many cases, compensations were awarded, but these were challenged in the higher forums on the grounds of non-applicability of the act. They said that this act is not applicable to doctors. Why are you applying to us? Varying judgments were given at that time. In fact, Madras High Court ruled that CPA was not applicable to doctors. So there were various kinds of judgments. Now, to solve this, to achieve closure to this issue, all these legal challenges across the country, they were placed before the Supreme Court. In 1995, the IMA versus VP Shanta judgment gave finality to the dispute, and it was confirmed that medical profession was indeed under the purview of the CPA. In 2019, a new CPA was passed. Supreme Court reaffirmed that it was applicable to the medical profession. So in other words, there is no dispute, there is no question of argument whether it is applicable or not applicable. Now, what has been the impact of CPA? Since the CPA has been in force for over three decades, 30 years now, we have enough experience, evidence, and material of its impact. Which means what has been its result, what has been its impact on society and on the healthcare system. But this question must be answered in a very balanced and unbiased manner from the perspective of patients, healthcare professionals, and the healthcare delivery system in this country. We have to coolly, calmly, and not get passionate about it. We are doctors, so this is bad. And the other side says, patients, the consumer says, no, these doctors deserve it. So, but we have to take a balanced approach and find out what is good, what is not good. I will attempt to do this as dispassionately as I can. Now, what are the positive impact of Consumer Protection Act? What good it has done? Let us understand. The aggrieved patients who have been provided with an additional and simpler avenue of redressal against malpractice and alleged acts of negligence in the course of their treatment, which is good. It is nobody's case that doctors are not negligent. It is nobody's case that doctors don't cause damage to the patient. And if that happens, definitely the redressal mechanism has to be there. Before CPA, this patient could only file a case in the civil courts under the law of torts or under the provisions of the Indian Penal Code or complain to the medical council, which of course has no powers to award financial compensation. The medical councils can't give 1 rupee to the complainant, but it can take disciplinary action against the doctor, including suspension of registration, permanent registration, temporary registration, warning, and so on. So these were the things that could happen. Now, again, what is the good that has happened? What good happened to the medical profession and to the patient and to the health system? There is more awareness of enhanced patient safety measures and error minimization checklists. I have seen so many hospitals, so many doctors are now making checklists. Before a patient goes into the operation theater, there is a checklist. Have you removed the jewelry of the patient? Have you taken the consent of the patient? Are the reports there? Has shaving been done? Has all the reports are there? And there are checklists so that you don't miss out anything. So why this has happened? This was not happening earlier. Right? People are now more careful. So which is good. There is improved record keeping and patient documentation, and I'm surprised. Sometimes from the district level, from small places, such beautiful histories are written so well. The resident doctors are trained so well; they write so detailed history and excellent. So which I'm very impressive. So why this has happened? This was not happening earlier because now you realize the value of documentation. Because as it is said, what is in law, what is not documented never happened. What is not documented never happened. Because if you didn't say that I did so and so procedure, but you didn't write it, the court says it never happened because it's not there. What is documented happened. Okay, so that realization has come. So it's a good thing. Then the role of communication skills have been recognized. And in many universities, they have been added to the syllabus. The undergraduate, postgraduate students, especially they are given lectures, they are taught on communication skills, how to communicate with the patient, how to convey bad news. Suppose a patient dies, then you just go and shock the patient, mar gaya aapka, you know. How do you communicate? How do you convey bad news to the patient and so on? So I think this is a benefit that has occurred. All right. Then there are greater efforts to update knowledge and skills. Now, I've never seen so many CMEs, so many lectures, so many seminars where the people come and talk. Now, today you have all come, you have taken the pains to come, the students and the others who want to know more about it. So so that this is protecting you and giving you ideas as to how to prevent litigation. Better understanding of doctors, of their legal and ethical obligations of the legal system. And I definitely can substantiate that. It was when I was a student or when I was a young boy, I remember, this is my memory, that though everybody said we used to trust our family doctor and we used to respect and all that. But I remember the specialists, at least in those times, were quite arrogant. I can tell you that. This is my memory as a child. They used to be very arrogant. They make you wait for 3 hours, and the way they used to behave like God, you know. So that has happened. That has gone away now. That has gone away. Everybody realizes patient. We have to respect the patient, and we are not. As such, the aura surrounding doctors, the image of demigod is no longer there, and we treat doctors as human beings, and that is how it should be. Then, of course, there's these are the good things that have happened. There's a realization of the concept of patient autonomy. It means patient owns his body. The patient owns his body. He has a right. He has a right to do. Your duty is to explain to him that, look here, you need this, you need this. This is what will happen if you operate. This is what will happen if you don't operate. And final decision has to be taken by the patient. Patient autonomy. He is independent. He has to take the decision. He is master of his destiny. And the earlier paternalistic pattern of doctor-patient relationship is gone. What is paternalistic means father. Paternal means father. So earlier it was as if the doctor was like a father. And how can the father tell anything wrong to the patient? So the patient had full trust. Paternalistic thing. I said, you need operation, that's the end of it. I don't have to explain why you need, what will happen if you don't get operated. And the patient used to accept it. That was the paternalistic pattern. That has gone away. And now we have what is called patient autonomy. He is the master of his destiny. He has to say, and you have to explain to him. And of course, there is a sea change, as Dr. Shenoy explained and the others explained about informed consent. There are a lot of judgments which explain that. There is more introspection, discussion, and debates by the healthcare professionals. Like today, we are discussing more, we are arguing, we are explaining, and we are increasing our knowledge, which is good. And so that's a good thing that happened. And quality assurance and accountability became the new buzzwords. Earlier, we thought, what is this quality assurance and what is this accountability and what is audit? Today, you have audit, you have prescription audit. Somebody, if you go to NAB, somebody will do your prescription audit. Your last 6 months prescriptions will be taken out. And then you retrospectively audit. And you yourself will say, oh, how did I write this? And you realize, okay, this was not correct. So audit, we never thought. We thought this is all for industry and business. Doctors ke liye kidhar aa gaya ye audit and all these things. So today we have realized that yes, and stricter controls by the hospital administrators. They are more vigilant, more particular about record keeping, documentation, and so on. So these are the good, very good things that happen. Now, what is the other thing that happened? Many patients were awarded huge compensations. Following the CPA, some of them, this compensation reaching astronomical category. Now, what is astronomical? Astronomy, what is the distance between Earth and the Moon? So, you know how many zeros are there. So, like that, when people got notice, a friend of mine got a notice where there's a Steven Johnson syndrome following some drug, and he got a notice, and he felt giddy because he could, the number of zeros he could not find out. It is 3 lakhs. So he told his friend, what is it? He said, it is 3 crores. He has demanded 3 crores. So now the astronomical, and that is a fact. Today after this 2019 CPA, the claims that are coming are in crores. The days of lakhs has gone away. And for those of you who have professional indemnity, etc., please make sure that you have an insurance of a large amount, because patients are claiming now in these kind of figures, and examples of large compensations have been given recently. 76 lakh rupees, 1.4 crores, 1 crore. These are actually in cases 1 crore 79 lakhs, 2 crores rupees, 11 crores was awarded compensation inclusive of interest in Kolkata in the Kunal Saha case, which was the highest award so far. Because it's not only the compensation, then the interest is calculated. Last 20 years interest de do aap unko saath mein. See, so this is what happens, and huge amounts. And let me tell you, there are people I know of an anesthetist who was given a huge award, 30, 40 lakh, who had to sell her property. To give that money, she had to sell her flat, one flat she had to sell. So astronomical awards had started giving, which is, of course, from the patient's angle, it was good. This huge awards transmitted a variety of messages to the patients, healthcare professionals, and to the healthcare system. some good messages and some which were not so good. So we will examine both of them. So the basic concept of compensation is principle of restitutio ad integrum, under which a person who suffered damage due to wrong committed to him ought to be restored to the position in which he would have been had the wrong not been committed. That is the basic principle of the calculation of compensation. Now, huge compensation, people criticize, okay, what is this, crores you are giving, what is this? So how people justified this huge compensation? What is the justification? And which is interesting. He says, all these are important. He says, large compensation payouts send out a strong message to negligent or unscrupulous hospitals and doctors and act as an effective deterrent. So a friend of mine said that, no, sir, this is wrong, you have written, how deterrent, suppose I'm operating, some damage occurs, I can't, just because somebody got a huge compensation, how does it, that accident may still happen, like in the case which Gopinath Shenoy mentioned, accident might happen. So how is it deterrent? So I said, no, it was deterrent. And the best example of how these huge compensations were deterrent is, there is a condition called ROP. You know that ROP means retinopathy of prematurity. That means in those babies who are born premature, they have a tendency of getting a retinopathy. So every premature, so there were 3 cases where large compensations were awarded because the pediatrician missed the ROP, missed this retinopathy, and the child became permanently blind because it was not diagnosed early. If it is diagnosed early, then it can be corrected. So that didn't happen. And so therefore now today what is the deterrence? Today every pediatrician knows any premature baby, immediately they say, "Arey, sabse pehla iska wo dekho, whether he has got retinopathy or no." Why? So good. So many babies would have saved their eyesight. Why? Because somebody was awarded big compensation, and now you realize, okay, no, this is important, you should do it. And they did it. So that is what they did. That was a good thing. Now, large payouts are the only way of improving healthcare in India. Medical councils have failed to regulate the conduct of doctors. These are, who is saying all this? The people who support large compensations. And large compensations would ensure better patient care. So that was how people were justifying. Now let us come to it. What is the flip side of huge compensations? What is the good thing that is not good that has happened with huge compensations? It is important to remember that though compensations will deter carelessness by doctors, it will also deter the desirable risk-taking involved in crucial medical decisions, which may optimize chances of recovery of the patient, especially in life and death situations. So because I'm afraid that if something were to go wrong, and then I might be awarded a huge compensation, I'm afraid. So I say, I don't want to take the risk. Why should I take the risk? And that patient might not get the optimum treatment because this doctor was deterred. He's afraid. Every day he reads in the paper, usko 2 crore diya, 5 crore diya, 25 lakh diya. He's afraid. So he doesn't want to take any risky decisions. So that is the bad thing. Fear of being foisted with liability will take away what may be the only chance of recovery of a patient in a given situation. So this is the ill effect of these huge compensations. All right. Now, this is a question which has always bothered me, that often medical accidents are compared with road traffic accidents. Now, how do I say that they're compared with road traffic accidents? Number one, in criminal law, suppose a patient dies and the relatives claim negligence. So what is the criminal charge? IPC 304A, which means causing death due to rash and negligent act. Now, do you know, this is if you're driving your car and you knock somebody on the road and the person dies, what charge will be applied? 304A, same charge. That means that was rash and negligent driving, and this is rash and negligent treatment. So you are using the same parameter, which is not fair according to me. Now, you can see the difference between road accident and accident in a hospital. If everybody was to be careful on the road, there should be no accident at all. Victims of road accidents, please remember, are healthy individuals or were so until the accident took place. Whereas in the medical setting, sick and diseased individuals with pre-existing medical risk factors are undergoing attempts to cure them of their illness, and all actions are being done in good faith for the benefit of the persons presenting themselves, and I may add, with their consent. Many of them may have unsuccessful outcomes of treatment. So how can you compare with a road accident? All right. Similarly, the other thing I'm saying why they are being compared is in compensation. When courts award compensation, in many cases, in that Kunal Saha case, first the motor accident vehicle multiplier formula was used. The multiplier formula, which means 75 minus age of the patient into 1/3 added for inflation minus 1/3 for the personal use. That was the formula. That is the multiplier formula used in road accident. Now we are using also multiplier formula in a medical accident. So I'm saying it is unfair to compare road accident with a medical accident. You can't do that. Here is a sick patient or fat patient, diabetes, blood pressure, heart disease, something happens to him. You are giving compensation as if he died on the road with somebody knocked him in the car, which is not fair. In fact, you are giving much more than what even the road accident person will come. Is the value of life of the person who died on the road accident different from the one who dies in the operation table? All right. So I think that is where something is not right. And even if everyone concerned, remember, in medicine, even if everyone concerned were to be diligent, accidents and mishaps and complications, unlike in road accidents, will still occur. They are going to occur. People are going to die. People are going to get complications. Even if everybody is careful, mind you. Hence, drawing a parallel with the road accident victim is unfair. It's both in criminal law, 304A is same, whether you died in the operation theater or you died on the road. Not fair. Now, these are, I told you what were the positive things, the good things, something that is not good. Now, there are some people who argue that, of course, this is an academic argument because we are already under CPA. So nobody is now saying okay, we should not be in CPA. But it says whether inclusion of medical profession under CPA is appropriate or not appropriate. Right? Those who feel that CPA is not appropriate grievance mechanism for patients, what is their argument? So I'm balancing you, I'm telling you good and bad. It says those who oppose say that it does not stand to reason that a life and death profession meant to heal human bodies is equated to business and commercial enterprises. You are making no difference. Imagine in a consumer court, there is a famous heart surgeon standing there, and next to him, who is standing in the queue waiting for his turn, is a fridge manufacturer. Uska warranty, he had given guarantee, and the fridge did not work properly. You are putting them at the same level. You are reducing the patient to a commodity. Is it not demeaning to both patient and doctors to be brought to the level of customer, grahak, and doctors to sellers? So patient is customer, grahak, client, and the doctor is a seller, trade. Is it fair to do that? Is it not demeaning to both, to patient also and to doctor also? You are reducing the level. And I think, what are the doctors called nowadays? Do you know? You're not called doctors. Doctors are called HCP. What is HCP? Anybody? Healthcare doctor. So you are, this is HCP. What is it? Healthcare provider. Much like internet service provider or XYZ service provider. You are a service provider, mind you. And so it is not right. So it is not appropriate. And therefore, the adverse reaction which happens in a hospital to a doctor, this should not be compared with a manufactured good or a service which has nothing to, which is not a life and death situation. Now, medicine is, we also have to remember that medicine is a complicated science. It dealing in with a complicated machine. Who has made this machine? God has made this machine. It's a complicated machine. All right? And the science is complicated, not easy. Doctors practice an inexact science. This is not, it's not an exact science, believe me. One that is subject to countless variables. There are countless permutations and combinations. Patient disease, patient factor, family disease, history factor, and which can produce unpredictable and sometimes unfortunate results. So the medical science itself is not an exact science. That should be recognized. That has to be recognized. In the era of high-tech medicine, the expectations of public from medical science have risen sharply because you hear people think that nobody should die now. That they are so advanced, robotic surgery, this surgery, that surgery, and now everything can be cured. So their expectations, thanks to the media, have gone up to very unrealistic high levels. So that is another reason. Now, what has been the bad impact of the CPA on professionals? All right. So one thing, the doctors have a tendency now to look upon every patient as a potential plaintiff. Plaintiff means complainant. He potential that he might, it may happen that this guy might, and especially if the patient is behaving oddly. And there is excessive focus on documentation and doing the medico-legally correct thing. So you are spending a lot of time on seeing what will stand scrutiny in the court. So you are that much time you have lost, which you would have given to the patient. So you are now worrying, no, ye medical legal dekho barabar hai ki nahi. As he said, oh, time barabar likha ki nahi. You are more worried about that. So you are spending less time on the actual treatment of the patient. And this is leading to high escalation of healthcare costs. The professional indemnity insurance premium, the insurance companies are beneficiaries of CPA. They have hiked their premium so high that they are jumping with joy because now people have to insure for 2 crores, 3 crores, and so on. All right. And getting acquitted. All right. You say, don't worry about it. There's a case against you. You will win. You show your documentation. You show this. You prove. Everything will be all right. But getting acquitted in a case in the consumer court after several years, it is a no-win situation for the doctor. It's a no-win. There is no reason to celebrate because the process is the punishment. He already got his punishment. The doctor already got his punishment through years of torture, and that the process became the punishment. Never mind if finally the court said, you are all right, don't worry. Okay? So this is the ill effect of the CPA. Now in the USA, it is not yet happening in India, and I won't be surprised if this starts happening in India. Some doctors started writing outside their consulting room, if you want to consult me, bring your lawyer along with you. So as you bring your lawyer, you let me explain everything. He say, yes, here, agreement is signed, like you're buying property or something like that. And you understood, I have understood. And don't be surprised, they take video consent. Now in USA, they take video consent. Because believe me, sir, in one case, all due process was taken, consent was taken, informed consent, complication. And what did the patient say? See, there are good patients, good doctors and bad doctors, but there are also bad patients and good patients also, please remember. So what this patient said, he told in the court, that this is not my signature. Doctor has, now he's done everything what you are saying here, do this, consent. He said, this is not my signature. Doctor has forged my signature. Now what do you do? So first you get forensic expert, handwriting expert. He can easily say, I have not signed, this is not my signature. What will you do? So what is the answer? What they do in USA? You sit down, there's a camera, take video consent. Video consent. Give one copy to the patient, one copy you keep, CD aap rakho. Tomorrow you say, play the video, whether I told you or I didn't tell you. Okay? So don't be surprised if that kind of thing happen. And don't be surprised if every hospital nursing home has to have an in-house advocate, in-house lawyer you have to keep. So good for lawyers. So this is another consequence. Now, faith and trust, what was mentioned, the commissioner mentioned, faith and trust, they are key ingredients in the process of healing. The CPA has resulted in a serious trust deficit between patients and doctors. The mutual trust has in fact been replaced with mutual suspicion. The doctor is suspicious if the patient is asking too many questions and saying, I went there, he says, "Ye gadbad lagta hai, ye thoda, I have to be careful of this fellow." And the patient is suspicious. I say, get a MRI done. He says, MRI, what's that? Ye isko commission milta hoga jarur. He must be getting commission. I don't need MRI, all right? So that mutual trust, how can it remain? How can we talk about the times gone past when these things happen? There cannot be a mutual trust. He is worried, both are worried, both think why he's referring me for this, there is some problem in that, okay? The patient, this I have already said, patient has become a customer, grahak, client, doctor is in HCP, healthcare is a commodity which can be bought and can be sold. You all know corporatization and all that. There has been an exponential rise in litigations against doctors. Adverse or suboptimal outcome of treatment is often equated to negligence or deficiency in service. So he's convinced, the relatives are convinced, my relative would have got saved, but for this, why he didn't do this, and because of half knowledge, or somebody saying, or even some other doctor saying, no, this should have never been done. So that is okay. Ultimately, you may get exonerated, but you have to defend yourself and go through the entire process. Okay? The patient hostility and aggression registered an upward trend leading to fear psychosis among the healthcare givers. So that is a fact. People are now quite anxious seeing patient. And I know of certain guidelines are there. Which patient you should be afraid of? There are guidelines. So one is if the fellow has relative in USA, be very careful. USA, Europe, they are litigious society. In USA, there's a disease called litigosis. Litigation ka bimari hai unko, So he says, my brother is doctor in USA, then be more careful of this guy, Or if he's criticizing the other doctor, he says, oh, doctor useless, he told me that, then again be careful. Tomorrow he'll tell another doctor same thing about you. So there are certain guidelines. So this is what is happening. That is a direct outcome of that. And then has come the practice of defensive medicine. Whether we like it, whether we don't like it, we have to accept that now everybody practicing defensive medicine is inevitable. It is inevitable. When in earlier years, I'm in practice since 45 years. When I used to operate a hernia patient, for example, I would just do few simple investigations. Get one blood, urine, that's all. Ho gaya kam. You look fit, otherwise clinically you're okay, heart is okay. Now today I'll do 22 investigations. I'll go do 2D echocardiography, do ECG, do stress test, do this. Why? Suppose something goes wrong. Then he says, oh, you didn't do this. Why did you? Why? So why should I take a risk of which I am not the beneficiary? If I do betting or if I do horse racing, bet on horse racing, I lose money, but I took the risk, I would have benefited. Here, I'm not benefiting by not doing investigation. So why should I not do? Why should I not be safe? All right. So defensive medicine. And what is defensive medicine? Let us know. What is defensive medicine? Defensive medicine is defined as doctors ordering tests and procedures, making multi-specialty references, go to pulmonologists, diabetologists, and taking other measures, not because the patient need these, but in order to protect themselves from any potential malpractice liability. I want to protect myself. So what's wrong in trying to protect myself? All right. So people say doctors investigate. I say yes. Yeah, they are over-investigating. And why are they doing that? Because they don't want to be told that, oh, in a rare case, so you didn't do this test, you ought to have done. That is the standard of care. And some doctor will come and give the evidence that, yes, sir, this should have been done. All right. It also, defensive medicine also includes the reluctance to accept critical cases. which are then referred to high-end tertiary centers for fear of liability. There's a patient who comes, he's little critical. I can treat him. I know if I do this, he'll be all right. But I say, better not to treat him. Better you go to Ambani hospital. There he will spend some 20 lakh rupees, which I would have treated him. But now I'm worried. I say, why should I take a chance? You please go to Kokilaben Ambani hospital. Okay. In the USA, 82% physicians order more tests than are necessary. $650 million are lost by American healthcare system. Why? Because of unnecessary tests and procedures in the process of defensive medicine. You ask any relative of yours who is in USA, for simple cold and cough, if they go, so my wife is a pediatrician, she gets call from America, suppose her patient is there, she says, doctor, this is the symptom, I used to come to you, you give treatment, by evening my child is okay. Here, from morning to evening, no treatment, they are asked for so many tests to be done, which is a fact. And how much money and time was lost there. So a similar effect in our country is on the way, but is something, it is similar effect. We don't know how many crores of rupees we may be losing in defensive medicine. Nobody has calculated. All right. But in a resource-challenged country like ours, we cannot afford it. Patient can't afford normal treatment. How they will spend for defensive medicine? So we are losing crores on defensive medicine. But what that effect is on the patient. Sadly, it's the patients who are affected. Right? Similarly, I am told several super specialty medical seats are lying vacant. Even government says, private says, super specialty, people say, no, we don't want to go. Neurosurgery, nahi jane ka humko. No? We'll do what we can practice. We don't need a high funda setup for that. All right. So they're lying vacant. This is a fact. Super specialty seats. A large number of doctors are migrating to other countries where doctors are more valued and respected. Large number of them. And this, I will prove it by quoting somebody whom you will respect, that they are going to Canada, they're going to USA. The moment they pass from here, don't think they're going to practice in Aurangabad. You will soon hear that fellow is settled in USA or Australia or somewhere. Okay. Apart from risks of litigation, the bigger risk of facing physical violence is deterring students from taking up medicine as a career. Because they feel, they hear that this ultimately something goes wrong, you might get beaten up. One doctor lost his eye, one doctor got multiple fractures. There was one from rural Maharashtra, there was a very rich farmer, they're agricultural. He was very proud, my son, I want to make him a doctor. He made him a doctor. And then one day, some complication took place in a public hospital and they beat him black and blue. He got fractures. He was in hospital for such a long time. And his father, the rich farmer, said, you please come back. I didn't make you a doctor to get beaten up. You please come, you do join my farming business. So I don't want you to be a doctor. These are facts. All right. Apart from risk, okay. Most doctors are not encouraging their children from becoming doctors. A lot of doctors, you ask them, you want your child, son, daughter to become doctor? He says, nahi, wo IT ka karega, wo karega, both. And doctor starts earning after age 35, he starts earning. And when does he retire and when does he save money? So he says, no, he will do IT, he'll do this, he'll do that. I have 2 daughters, both of them, I tried a lot. They refused to. They said, we don't want to become doctors. Then I told them, at least one of you marry a doctor. They said, we don't want to marry doctor also. So now the result is neither my daughters are doctor, nor they have married doctors, and I am left high and dry, and I have to sell my hospital now. What is the other impact on the healthcare? What has happened today? I'm talking of the real situation, because last 40 years, we have this medico-legal cell in Association of Medical Consultants, which is a pan-India body, and we specialize in helping doctors in facing their medical-legal problems. So day to day, every day, we get 3-4 calls. Somebody has got legal notice, somebody medical counsel has done and all that. All right. So experienced doctors are retiring early. which is a severe loss to society, which is already facing a skewed doctor-patient ratio. Our doctor-patient ratio is already poor, and already people are retiring early. They want to retire early so that they can live a peaceful. And they say any moment anything may happen, so better to retire till I did not have any case against me. So then we will see. So there's a loss. Their experience is a loss to our society. Small, and this is a fact, what I'm telling, it can be proved by figures. Small and medium-sized nursing homes are shutting down, worsening the hospital bed population ratio. A lot of medium-sized nursing homes, every day, if you see, you get advertisement, nursing home for sale, for this and that and all that. So that is another thing. This is again happening because of the climate that has come up in the country. Bright students, they are not finding pursuit of medical profession attractive. So what will happen? The bright students don't want to go for medicine. So the quality of the doctors will plunge. You will not get the best students you will not get for medicine. All right. And doctors are now switching over to other professions. This is also a fact. I can give you statistics. All right. We have one doctor sitting behind you who just spoke before me. He was a good gynecologist. He had a hospital. He said, no, sorry. He has sold his nursing home. He has become an advocate. So I said, why did you become advocate? He said two things. One thing, no night call. रात को आता है, पेशेंट को दुखता है, पेशाब नहीं हुआ, पेशेंट को पेट में दुखता है, उल्टी हुआ, रात को कौन जाएगा? Now he doesn't have to get up at night. Nobody calls him, मेरे को stay order चाहिए रात को. All right? And second reason, most important reason, what he told me, said no CPA for me. Even if I lose the patient's case, no CPA, not to worry. Because lawyers are exempted from CPA. I have no clue why they are exempted from CPA. There is a case pending, I think, where their court has still to decide whether lawyers should be included. I'm not saying I hope they are not included. Just because I'm suffering, I don't want somebody else to suffer. So I'm not saying you put them, but I'm just telling you. So this guy told me, okay, no night call, no CPA. I am happy. See, he looks so happy. Earlier, he was never looking so happy. Okay. Now they're shifting to other professions. So one was the advocate. Practicing advocate, here he is. IPS, police commissioner. I know his name was Dr. Gupta. No, whether he was a medical doctor or what. No. But I know of many medical doctors who are IPS officers. Many medical doctors. We had one police commissioner who was a doctor. So they're going to police. Oh, acha. Instead of facing police, you call the doctors. So, jawab do humko. Okay. Then hospital administrators. Okay, still he is something. Insurance, pharma industry. Okay. Builders. I know of 2 doctors who became builders. They are minting money. They're very happy. Hoteliers. I actually know one anesthetist. In Andheri, he has started a hotel. And we hold our medical meetings there. He gives us concession, Okay. Nice hotel he has opened. Regency out there at Andheri East. Okay. Hotel. Then music director. You will be surprised to know. In Goregaon, there's one Dr. Vijay Bhave, pediatrician. He is now a music director. Very good music director. So people are also kind of shifting to other professions. Politicians. So very good profession. They have become ministers. We had health ministers who were doctors. Very good. But of course, they didn't help us. But though I thought they'll help us, they never help us. Okay. So politicians, share brokers, I know. Of course, people were doing part-time, then they gave up medicine, now share broker. So in other words, people are shifting. Now the other point, this is my personal viewpoint, which I think is for consideration, that when we charge doctors, say that you are negligent, you did this, you should have done that, you should have done this, we are looking at a perfect scenario, perfect, zero error, perfect. That's not correct. Should not courts, should not the law factor in the terrible lack of healthcare infrastructure in our country while upholding charges of negligence against the doctor? See, what is our infrastructure? We never talk about that. We have a terrible infrastructure. We didn't have oxygen. Simple thing like oxygen, people died because there's no oxygen. All right. And what about things like, I'll talk about that later. The government spending on healthcare is 1.28% of the GDP. Only that much money they spend. Lesser than underdeveloped African countries. Even Bangladesh is spending more money. Brazil, South Africa, African countries are spending more money than we are spending on healthcare. So should we implement? So this is my thinking. Should we in India, I'm talking of in India, should we implement a first world regulatory structure? What does that mean? First world, we refer to the Western country like America and all. They are first world, right? That structure, like large compensation from where we have got? From USA. This is USA model, all right? In a country with pathetic infrastructure, like poor blood banking system, shocking lack of qualified nurses, the ratio of the nurses is so poor that we don't start nursing colleges. We don't want to get more. There is a need for qualified nurses, all right? Paramedical personnel, non-existing emergency response system. In USA, just that 952, some number you deal within 5-6 minutes, emergency ambulance will come to you. Here, what will happen? You will not get for half an hour, 1 hour, you will not get ambulance. Ambulance ko phone kiya, he says, oh, diesel bharne ke ambulance. What will you do? So this is when the person, the tool, I'm a craftsman. What are the tools? You're not giving me tools. And then you say, I'm the frontline man, so for everything I am responsible. You patient didn't reach in time, sir, ambulance nahi hai. Oh, don't talk about ambulance. Patient ka time mein kyun nahi pahuncha hospital? Why you didn't transfer? Okay. So should we, that emergency response system is not there, primitive ambulances and so on, which leaves doctors hamstrung in exercising their professional skills. My skills, I am restrained because I don't have this and I don't have that. All right. So should we, same system, then it should be apples should be compared to apples. If we don't have infrastructure, then that should be taken into account. Like in a place near Palghar, some patient died, blood, which are a blood bank nahi udhar. So the nearest blood bank is some 10 kilometers away. So he has sent the relative 10 kilometers. Udhar nahi hai. He is searching for blood. And then the patient, now what is his fault? He can give blood. He knows blood is to be given. He knows how to give blood, but he has no blood. So should we not consider this poor, pathetic infrastructure? It's improving. I'm not saying that. All right. So to summarize, CPA is a welcome legislation which has helped protect consumers and consumerism. It has provided an additional grievance redressal mechanism for patients since healthcare services are within its ambit. There is no question about it. It has helped regulate healthcare in a number of ways which have benefited patients. There's no doubt about it. But let me quote this gentleman, which I said earlier, and he is the Chief Justice N.V. Ramanna, as late as 24th August. We are in September, 24th August, just before he retired. What did he say? It's not I may say, you may say, somebody may say, but what did the Chief Justice of India say? He's saying, how does he has come to know, that's why he's saying, that these are his words. He's on the YouTube, his video is there. You can hear it. Doctors are shifting to foreign countries. He knows. Yes, doctors are shifting to foreign countries. There is unchecked corporatization of hospitals. There is lack of severe working environment for doctors, violence, etc. He knows it. High cost of healthcare, and several false cases are being lodged against upright and hard-working doctors. These are his exact words. Who is saying this? Chief Justice of India. So that can't be wrong. All right. So undoubtedly, everyone doing a responsible job must be accountable for his or her actions, especially doctors. CPA was applied to medical profession, I have no doubt, on account of lack of auto-regulation. There is no question about it. If medical councils had done their job well, these things would have been different. The good impact and the not so good impact of CPA I have discussed. I already told you. It may be worthwhile modifying the CPA provisions by examining modalities in other countries. I have studied what happens in New Zealand, Australia, other countries. including no fault, what is called no fault liability. We're not going to go into all that. Capping of compensation, not so much compensation to be awarded, which has the doctor has to sell his house. Creating professional tribunals and establishing public fund for compensating medical injuries. Let us call it medical injury. When it happens, the doctor is the second victim. He is called the second victim. When a patient dies, doctor is the second victim. And you know what happened in Rajasthan? This gynecologist committed suicide. She committed suicide after patient died of PPH because the police applied section 302 murder on her and she was terrorized. She thought she'll go to jail and she hanged herself in her own nursing home. All right. So we need to re-examine and think about it. And this is my final message. Because there are a lot of young doctors here, a lot of students, there are people who are aspiring to do great in medicine. I don't want to disappoint them. I don't want them to discourage them. I want to give them hope. This message for all doctors is that we belong to a very glorious and proud profession, one that was the most respected profession. We must all strive to restore the honor and dignity of our profession. By isolating the black sheep, I'm saying that, and practicing ethically, and by being humane and compassionate doctors. So this is my message to all those who are young people who are becoming doctors. And our hearts should beat with empathy for the patient. You should treat the patient as if he's your own relative. How will you treat your own relative or your own brother? And your heart should beat with sympathy and not mechanically like this. Your heart should not beat mechanically. All right? You must have sympathy for the patient. Whether CPA is there, not there, bad effect is there, not there, you are a doctor, be a good doctor. Thank you, ladies and gentlemen.
Thank you so much, sir. For the panel discussion, I would like to invite Justice Shri R.K. Agrawal, Honorable Dr. S.M. Kantikar, Advocate Dr. Gopinath N. Shenoy, and Dr. Lalit Kapoor sir for the panel discussion. Dr. Lalit Kapoor sir will be conducting the panel discussion. The audience is free to ask any insightful questions they may have.
Okay.
And just keep it here. Good. Okay. Yeah, I think let's start with the panel discussion. Probably people are getting now too much fed up or with overdose of legal things. But so we'll get around quickly with the panel discussion. Now, my first question is to Honorable Justice Agarwal and Kantikar sir. Both of you have to answer. Let's sir, the original intent of the Consumer Protection Act. What did it say? It said it is speedy. And second, it is cheap. So, but what is on the ground? An average case in our experience, correct me if I'm wrong, in the district commission is 5-6 years at least in the lower court. And then if it goes to the higher court, another 5-6 years. And there are cases which are getting decided after 25 years also. So what do you think is the reason for that? And is there some way we can get back? It said originally said 90 days, within 90 days. And now sometime it is not 90 months also, which is a fact. So what could be, sir, what could be the reason? And to that extent, it has not subserved its purpose. This is my question. So if you can just throw some light on that.
You see,
Sir, mic is this.
you see, the question is the object of the Consumer Protection Act as enacted has not been achieved. But the reason is that nowadays consumers have become, or rather our countrymen have become more aware about their rights. And they think that under the Consumer Protection Act, without going to the civil court, where complicated questions of law and facts are involved and a lot of evidence has to be adduced, cross-examinations have to be done, they can get the case decided at an early date, right? Now, because the filing has increased, the infrastructure has not improved.
Correct.
Right? The vacancies are there.
That's right.
And then adjournments are being granted liberally.
Correct.
For which all of us are responsible, I would say, the lawyers, the litigants, and of course we also.
Correct.
Right? That adds the pendency of cases, and I would say that at present, the National Commission has a pendency of more than 23,000 cases.
Correct. Correct.
Right? We are working hard, but we cannot dispose it of. We know.
Right.
The 90 days period specified in the Consumer Protection 2019 cannot be followed for the next 5 years. It cannot be followed.
Yeah. So it's not a speedy, it is speedier than the civil case.
It is speedier than the civil case, but if efforts are made, if the procedure is so streamlined that, look here, when a complaint is filed, the complainant will have to file all the documents which he wants to rely upon. There is no question of giving any chance of filing further evidence.
Correct.
And the opposite party also, when he files his written version, he should file all the documents because he has a copy of the documents which the complainant wants to rely.
Also. Correct.
Right? So all the documents are filed and there is no question of examination, cross-examination or getting an expert report. You apply it.
Correct. Evidence Act is not applicable.
Evidence Act in true sense is not applicable. The principles are made applicable.
Right.
Like under the Consumer Protection Act, the Code of Civil Procedure has not been made applicable.
Correct.
But nonetheless, the Honorable Supreme Court in so many cases have held that Civil Procedure Code applies.
Correct.
So you have to follow it.
Right, right.
So that can be only a way and mean to cut short the time spent or taken for deciding a case.
Correct. Kantika sir, you would like to add anything?
It was explained. What more? Repeated adjournments only. What I feel. The it is the fact and truth also. The cases are taking 1 decade. Medical negligence
Yeah,
cases,
exactly.
1 decade average. If
Yeah.
the study shows.
Correct.
Then the question before in my mind also, what the patient will get, complainant, and what doctor will get. Doctor will throughout 10 years, 1 decade, he will be under stigma.
Absolutely.
Stigma, and but for this something now, as the lordship also told, but this is a system failure or what I feel, because what you can do now to satisfy both adjournments to be given. If we are harsh and we dismiss on the spot at the time of admission hearing or after taking the written version, and so if we decide, or such system should come, if you won't come 2 times, the matter will be decided on the record.
Correct.
That's all, finish it.
Yeah.
Whatever
But you think something needs to be done?
it is overhauling is necessary.
So why I'm asking this question, particularly why I'm interested, because it's delay for the patient is okay, but delay for the doctor also. It's a torture for the doctor. For 10 years, he is hanging. He doesn't know what is going to happen. And which brings me to my next question. That suppose the case took 10 years to come up. Now, sir, I'm the doctor facing the consumer court. Case took 10 years. I was not responsible for 10 years going on, right? It was not my fault that it went on for 10 years. And at the end of 10 years, the consumer court says now pay interest also for 10 years. Is that fair?
You see, so far as this, under the Code of Civil Procedure, the liability for payment of pending interest is upon the courts, right? Though they can grant 6% interest, of it is a commercial transaction, the Interest Act applies, the market rate can be granted from the date of filing of the suit.
Correct.
Right?
Yeah, that's a long time.
So, merely because it has taken a long time to decide a matter, that will not absolve the parties for the liabilities which may arise. The only way out is, look here, according to my experience, little experience in the National Consumer Dispute Resolution Commission, 3 types of cases come. One is real estate developers, purchasers and the builders. Second is medical negligence. And third is the insurance cases. Other cases are only, I can say only 1%. Regarding sale and purchase of goods or lifts, etc., whatever it is, right? Defect services, other services. So, if like the commercial courts which have been established in the high courts to deal with commercial matters, if under the Act a power is given, of course, the President has the power to constitute benches to decide cases. But if that is adopted, then perhaps the pendency of some of the type of cases, or class of cases may be reduced.
Right.
And then a collective decision has to be taken, both calling the members of the bar and all the members of the commission as to under what circumstances in which cases adjournment will be granted.
Correct.
Right? Otherwise, if the adjournment is being granted, then there is no question of deciding the matter.
Right.
Because the lawyers, I won't like to say, but if the lawyer seeks an adjournment, he is appearing for the complainant one day, and the other lawyer is appearing for the opposite party. He complains that he was not told about it.
I know.
But then that very lawyer, when he appears for the complaint, he will do the same thing.
Correct. Dr. Shenoy, you want to add anything quickly?
See, I basically deal with medical negligence. I don't take up any other cases. And I basically argue in front of sir. Medical negligence matters, once you start arguing, it consumes a lot of time. It is not like arguing an electricity bill case or a travel agent problem. that argument itself takes
Correct.
a
It's
long
a complicated.
yeah, it takes a long time. And writing a judgment for a medical negligence matter consumes a lot more time from the judges than writing any other matter.
Correct. It's not simple.
Yeah. So collectively, if you put all these things, there is a huge backlog.
Okay. So we have
which
some
possibly
explanation.
everybody is
Yeah, exactly. Now,
I would like to add one thing. Mr. Sinha has said it takes a lot of time. I would like to disagree. You see, the principles of law has already been laid down by the Honorable Supreme Court. In Samira Koili's case, in Jacob Matthews' case, in Ansal Agarwal Agrasen Hospital's case, and so on and so forth. Principles are well known. Facts are stated by the complainant, either admitted or denied by the opposite party, that is the hospital or the medical practitioner, right? Now, if you apply your common sense, the matter will be decided very early. I give an example. I was sitting with my brother. A medical negligence case was filed by one of the lady complainant. She had delivered a child under surgery by a gynecologist, right? Something went wrong, whatever it is. Either the relationship between the doctor and the patient went wrong. She went to another doctor, got treatment. Some disease occurred subsequently, or maybe it was there. Then she went to a hospital in Bombay. I would not like to name the hospital. In the first round of investigation, the disease was not detected. In the second round, it was detected. An operation took place. Then she filed a complaint against the first doctor that she was negligent. So I put a simple question, though it was heard for about an hour or so. My brother applied his mind, I didn't apply because I don't have any mind to apply. Right? I simply put a question to the council that, look here, whatever you say on the facts, let us examine it. You say this was the disease which occurred because of the negligence of the first doctor.
he missed the diagnosis.
Right? I said, you went to this second doctor. The first doctor did not recommend the second doctor. The second doctor was your own choice. At the time of second doctor also, the disease was not detected. Third doctor, hospital, first time it was not detected. Second time it was detected. So how can you hold the first doctor negligent? Had the disease been detected by the second doctor, then of course the first doctor.
Correct. That
And
becomes difficult.
the plea taken was that there was some, what you call, discontentment or negligence, or the doctor was not happy with she did not note the disease is not correct.
Correct.
So it was decided then and
So
there.
logically,
Yes.
you apply simple logic. That's great. So now, sir, one more thing that bothers me. There's something called statute of limitation. It's a legal term. What it means is, statute of limitation means in how much time a patient can complain. You operated the patient today, all right? Within how much time can he complain? In consumer court, it is 2 years. That means within 2 years, he must complain. After 2 years, he cannot complain, or his complaint is not valid. He limited within 2 years, and 2 years I thought is a long time. Okay, but there is a provision which this delay, somebody may file after 4 years, and he say apply for condonation of delay. Okay, sir, I was busy, my mother was not well, please, I could not apply in time. And they are condoned. They can condone the delay. Instead of 2 years, he came after 4 years, and they said, okay, ठीक है, माफ कर दिया आपको, चलो. Huh? And the case starts. So this has always bothered me, that why are our consumer courts so liberal in condoning?
Yes.
On one hand, we have huge pendency. Now here is this guy who didn't, 2 years he was sleeping. Then 3 years he was sleeping. 4th year he gets up. So why don't we apply the rule of law or whatever is there and say, sorry, you missed the bus, you should have come in 2 years. But I've seen so many cases which are easily condoned. I mean, why is that? Though it is, Consumer Act is pro-consumer, I agreed. But
Yes.
I thought this is not right.
You see, mere pendency of huge number of cases cannot be a ground to decline condonation of delay.
No, I agree. But
Right? So far as delay of 4 years is concerned, there may be good causes shown in the application as to why the complainant did not approach earlier. Then the other thing may be, if it is a continuous cause of action, the period of limitation will not run. Right? In cases of medical negligence, in cases of purchases in real estate or in insurance also, the cause of action may arise from the date of repudiation of the claim.
Fine. That
not
is
from the making of the claim.
discovery rule.
That's-
So that is fine.
And so far as medical negligence cases are concerned, if you hold that there is no continuous cause of action, then the decision rendered by the Honorable Supreme Court in 1977, Muhammad Katiji versus Land Acquisition Officer will apply, where it has been held that you should take a liberal view. First thing, because nobody is going to harass the other side.
Yeah, but there is one more question that arises out of it. On one hand, we are told that you must preserve records for 3 years. All right, after 3 years, I'm well within my rights to destroy the records. Jalado, okay, by informing. After 3 years. Now he comes after 4 years, 5 years. Now, where does that leave me?
No, you see, under law, if you are required, if the person is required to maintain the record for 2 or 3 years.
3 years.
And the complainant comes or the patient approaches the commission, district or state or national commission after beyond 2 years with an application saying condonation of delay. Even though the delay is condoned, the other side will not be penalized or no adverse order will be passed. View will be taken merely because the records have not been kept.
But how will he defend himself?
No, he will say that these records have not been maintained and so.
But will you accept that? I mean, that means you will dismiss the case.
If the doctors say, as per 1.3 regulation, MCI,
Yeah.
we have preserved only for 3 years. That is valid ground. This is the best defense for the doctor.
So that will be taken into account?
Yes.
Okay. All right. And
in fact, that will be a plea which will be very good in his favor.
Correct. Okay. Okay. Sir, the next question is, I spoke about the high astronomical compensations. So what is your view on capping of compensation? Do you think there is a case where in a country like ours, 2 crores for one gynecologist, from where he will bring 2 crores rupees? And our doctors are also foolish, I would say. After knowing everything, they don't take proper professional indemnity insurance, or they will take for 10 lakh, 20 lakhs, and then the order is for 50 lakhs. He has to put the remaining from his pocket. All right.
That's right.
So do you think there is a case for capping like they do in US? They have done in many states.
You see, so far as capping is concerned, only the parliament can do it. And that is on the basis of the materials which may be placed by the medical fraternity. Right? Normally, in exceptional cases, only compensation of 2 crores or 1 crore is awarded. Not in all cases.
Yeah. No, I agree.
And if in exceptional cases, compensation of 1 crore, 2 crores are awarded, then there must, in the order, there must be sufficient reasons for it.
Okay.
Like in Kunal Saha's case, the Honorable Supreme Court awarded a very huge compensation.
Yeah.
They gave reasons for it.
Yeah.
Even if the National Commission is awarding 1 crore or 2 crore damages, some good reasons are given.
Correct.
And that is open for scrutiny in appeal before the Supreme Court.
Correct. Yeah. And the good thing I may let you know is that they are very considerate, most of these courts, that if there is a hospital and a doctor involved. Now in Kunal Saha, it was at Emory Hospital in Kolkata and 2 Dr. Mukherjee and 2-3 doctors. 90% the hospital was asked to pay and doctor was asked to pay. So I think there is a theory which, I don't know, I should use that word, theory of deep pocket. Whoever has a deep pocket is asked to pay more. The hospital, they said, can afford. So, I mean, I don't know whether that could be a consideration. They were considerate. The doctors had to pay not much, I think 20 lakhs or something like that. But the hospital had to pay the bulk of the amount. So maybe there is some kind of fairness as far as that is concerned. Now, sir, this very, very important question which is bothering me a lot. Now, all over the world, there is a system called ADR. What does ADR means? Alternate dispute redressal. All over the world, it says that cases should not go to courts. Courts are overburdened. You should settle before it goes to the court. Alternate dispute. You must settle compromise, right? Out of court, this court, and all that. You should do that. And now in the new Consumer Act, which has replaced the old Consumer Act, there is a clause for mediation cell. Each consumer forum is attached. There is attached a mediation cell to whom the court can refer. Court feels ke nahi baba jao pehle aap dekh lo, you try to settle it among yourself. If that fails, then of course they have a right to come back to you. Am I right? Now, what is bothering me is that in the rules, if you see, I have brought the actual words.
It doesn't apply to medical services.
Yes. So I'm saying in the rules, it says that mediation or settling like that not allowed in medical negligence case. It says in medical negligence, you can't settle. And in my opinion, if there is any category where this settlement should be allowed, it is the medical sector. I think it's not right because it is good for the patient, good for the doctor, good for the system. One less case for you to hear.
I give a simple reply to it. You see, under the rules have been framed by the central government. Yeah. They have excluded medical services from mediation.
I think they have said in case of death and grievous hurt.
Medical negligence?
No, sir, they have said.
You read it, medical profession, it has
matters not to be referred to mediation. It says matters relating to proceedings in respect of medical negligence resulting in grievous injury or death.
Very well.
So they are saying, suppose patient didn't die or didn't get grievous hurt, but those would be cases which are rare.
That will be rare, but if the medical profession wants that their entire activities or whatever treatment is, they should come under the mediation, then they have to make a representation to the central government.
Absolutely. So what you're saying is right.
But the other thing is, despite this specific provision that you will not refer to the mediation cell, but it doesn't prevent the presiding officer of the consumer forums to call the parties in chambers and discuss it.
And discuss it. Yeah.
And discuss it and arrive at a solution.
I see. But is there a provision for that?
There is no provision. I may tell you my personal approach in matters relating to real estate, where I feel that the matter can be discussed and solved, give and take policy can be applied. I used to call the litigants, not the lawyers, in chamber.
The parties.
Parties. And asked first the complainant, what is your grievance, what you want? The other side used to hear, then I used to ask, what is your response? You want time, you take time, come next time. In 90% cases, the matter was
very good, excellent. I mean, that is great. That
mediation had not come at that
but
time.
Sir, you are going beyond the rule, actually.
No, rule is for mediation. Mediation is done by mediator.
You're not calling it media. Okay.
I am not the mediator.
Okay. This is a good way of bypassing the rule. Okay. Yeah, because why I'm saying this is important for...
And in 1 or 2 cases of medical negligence also, settlement was arrived at.
Correct. No, I think this mediation we should represent as associations, as medical profession, to the Ministry of Consumer Affairs, who has framed these rules, that it is important to do that. Why, I'll tell you why it's important. Because in Mumbai, our association, that is the Association of Medical Consultants, we have a group insurance policy with the insurance company. And we have an MOU with the company. And we have said that if our association decides, the technical committee decides that this case should be settled. Now, which case should be settled is a case which is indefensible. In our opinion, if a case is indefensible, we feel on the face of it, there is no chance of winning. Suppose I've left an artery forceps in the abdomen, a scissor in the abdomen. There is no way, this is res ipsa locator, there's no way I'm going to be exonerated. In fact, the court may, so what we've told the insurance company, that irrespective of this mediation, we will settle it. They have a provision saying out of court settlement. So for a long time, we were kind of cheating them by calling the two parties and saying how much, kitna aapko chahiye, acha chalo, 10 lakh rupees. And we were telling the insurance company to pay 10 lakh rupees, saying out of court. Then one day they caught us. They said, how do you call it out of court? We said out of court. This is not out of court. It has not gone to court, so where is out of court? So said this is pre-litigation. So in our next MOU, we said, sir, you write pre-litigation, even before he has gone to court. And several cases, I'm happy to inform you, we have settled in the interest of the patient. Patient is happy, the doctor is happy, but we get an MOU signed. Our advocate prepares an MOU that he is not going to make any further claim, though that may not be very valid in law, because it happened only once or twice, when after taking the money, after signing MOU, he still went to court and said this was got under duress. It's like they showed me a gun and said, either sahi karo. And so I had to go. He did that. But his case was dismissed, I must say, by the High Court, that this is all rubbish. You have signed, you have taken money, now get lost from here. You know? So this pre-litigation, so which we are doing. So that is my interest in saying that this is not fair. But if you, as you said, you call in your chamber, then that would be excellent. That will be full proof. Then the consent terms, can I put the consent terms in front of you and you put a stamp?
You see, the consent terms which the parties agree, there is no pressure or request on my side that you agree. It is the parties who, with their open mind, have agreed.
Yeah, but
and those terms form part of the order.
Sir, but will you put a stamp on that?
If that forms part of the order, my signature is there on the order.
You will give that, acha.
And then it is also said that it will not be treated as a precedent because there is no case finding of fact that medical negligence has been committed by anybody.
Correct. But there are many cases like that which we have settled. For example, a lot of the radiologists who do this, what they call that, prenatal anomaly scan, and they have recently 2-3 cases, they have missed the anomaly. In one case, the fingers were missing and he says, no, baby is normal. Or heart defect was there, he said baby is normal. And then they failed. And so we did settle. We discussed, of course, we can't settle all cases. Some of them say, हम तो उसको 1 crore मिला था, हमको तो हम कोर्ट में ही जाएगा, तो आप कोर्ट में जाओ. But we do try to do this. That's why to me, this question was a little important about this mediation, which I thought was not a very wise thing. You should allow mediation in this case, because then the insurance company also will not argue, sir. Then insurance company, because it has come from the court, then they are bound to give you. Then they cannot say, no, we are not giving, you know. And I think this is the last question, because we can go on and on till midnight. So this is the last question. But you probably are also tired. Is this admission of case, can the admission of a case be done little more stringently, so that at admission stage, or rather, let me put it this way, what percentage of cases you reject at admission stage?
So far as I am concerned, I don't reject any case at admission stage.
Don't reject any case.
Because I follow the principles of civil law, where you file a plaint, the registry will only check whether it is within limitation, cause of action is arisen, and court fee has been paid as per the relief claim.
Oh, I see. Okay.
So they have to issue notice.
Okay.
And since I was practicing in the Allahabad High Court, there the first appeal lies as a matter of right on facts and law.
Correct.
Arising out of civil suit, right? So the practice was that you file this appeal before the registrar without a stay application. Then the registrar will admit it.
Okay.
Under
So
the rules.
chances are less of.
It won't be dismissed.
Okay.
Because he has to admit.
Okay.
Then you file a stay application, then it will be stayed, and then the court will decide only on the stay application.
Yeah. But sir, what if it is a very obviously frivolous case?
If you see, exceptions
Still you will admit him.
Exceptions are always there. If you are claiming an consequential, what you call pecuniary damages of crores, so it has to be dismissed. Supposing you have placed an order of purchasing a mobile from Amazon or Flipkart or what, the mobile which was sent or delivered to the purchaser was faulty or it was not there. So all right, you filed a case for refund of that money or some damages. But if you claim pecuniary damages of several hundred crores, it is what?
Correct.
It has to be
So
dismissed.
that you will reject. I see. Kantikar sir, you want to say something?
Yes, at admission, first we see the defects. If defects are not cured, time will be given. Repeatedly defects are not given, then it applies. He want to harass the doctor or the other side. This will be very seriously taken. Then if the complaint is frivolous, because I see medical negligence, if I feel frivolous, so I call I hear the argument and I dismiss that.
Okay.
And thirdly, if the compensation, if he's claiming, sometimes we got 100 crores also. He is claiming 100 crores. So such complaint means it is just to harass the
Obviously, it is meant to harass. Yeah.
Sometimes we dismiss with cost also. There was provision in the previous act, section 26, I think. So this is possible.
So that brings me to the question, in this new Consumer Protection Act,
It is
this
not
privilege has been removed.
It is not there.
But that was a good clause. Why did
And
they
in
remove
the new Consumer Protection Act, if the complaint is not admitted for 21 days, you have filed the complaint and it is deemed to be admitted.
Huh?
Deemed to be
Admitted.
deeming provision.
Oh.
And moreover, there the bench can decide. Suppose if it is admitted, then bench can decide after filing the written version also. At any stage, it can hear and decide the matter. If it feels unnecessary delay, they are seeking adjournment. Many times, what happens? The complainant is in US, somebody is in US, and we are not getting the documents. What it is going on? So we dismiss it.
Correct. Great. I think we had excellent information. And now, sorry, some audience questions quickly. Just three questions. Yeah. Mike, take the mic.
Sorry. Do we have any proper consent? In every such symposium, we listen that consent should be such, but we don't get any model consent. Can you enlighten us?
I will tell you something.
Yeah.
In every talk which I gave on consent, I always say that every consent should be procedure specific or operation specific, which means suppose I'm doing a cholecystectomy, then the consent should be for cholecystectomy and not for any XYZ operation. Because I'll tell you about even another thing which I wanted to ask. In cholecystectomy, one complication is of injuring the common bile duct. It is a serious injury. If you damage the common bile duct, it's a serious injury. But when you write in the consent, if you take a general consent, it will not be written injury to common bile duct can happen. When will that happen? If you have taken a consent for cholecystectomy. But the important thing is that like in that one judgment, you said that patient, Samira Kohli, that patient should not get frightened. How much to tell the patient? How much to tell what all can happen? Now, Samira Kohli says, or rather that foreign judgment says that up to if it is over 10%, then only you should tell the patient. Now, there is again a problem. I have a problem with that. Because common bile duct injury in a gallbladder operation, what is the incidence? Anybody knows? 0.5, perfect. 1 in 200. Sir, in 200 cholecystectomies, 1 injury to common bile duct can occur. So what is the incidence? 0.5%. And how can you have a consent for cholecystectomy without saying CBD injury can occur? And they say 10%. Here it is 0.5%. So again, there is something not right, because if CBD injury occurs, he will say, you never told me, it's a serious injury and it's a known injury. He said, doctor never told me that CBD can occur. So it is how much? He's right, 0.5, 1 in 200 cholecystectomy. So no, these lot of things are there. And as far as your question is concerned, everywhere I go, I tell all associations, suppose you're a surgeon, then the surgeons, ASI, the surgeons should, in fact, they had approached me also. How many procedures are there? At least 5, 6, 7 procedures. Cholecystectomy, appendicectomy, bowel resection. Please make specific consent for that. And I go to the extent of saying you translate into 4 languages. You have to do it only once. There's a one template, you make it. We had done in our association Hindi, Gujarati, Marathi, English. We have 4 types of consents. Our member can just go to our website, as is that, and take it. But they are not good consent, they are old consents. But association must make procedure-specific consents and give it to their members. Let it be uniform. And the other thing about consent, which I must tell you because I feel strongly, one mistake which we all make is we don't give a copy to the patient. Please take a procedure-specific consent and give 1 copy to the patient. Let him take it home. Because then he says, like in the R.G. Stone case in Delhi, where rightly I think that judgment was a good judgment, though people said it was not good, said you left blanks there. And how can you leave blanks, take signature? Because it's like taking a blank check. Either sahi kar do, then amount I will fill afterwards. How can you have pre-printed form with a blank? Because in the blank, you will now afterwards add. Suppose something happened, now you will say, CCC, you have signed. You know, so it should not happen that way. But once you give a copy to the patient, now neither he can say nor the court can say it is with him. See, it is very transparent. Give 1 copy to the patient of that consent, which some people are doing. I had eye surgery. They made me sign 2 consent forms. One they said you take it home, and one they got with them. Small thing, but it would help you.
Sir.
Thank you.
Yes. बेसिक क्वेश्चन, मैं एनेस्थेटिस्ट हूँ, काफी टेक्निकल क्वेश्चन पूछ सकता हूँ. पेशेंट को क्या इनकम पूछना चाहिए? वो उनका लेकिन वो छोड़ दो. इंडिया इज ए कंज्यूमर कंट्री. यहाँ बहुत बड़ा मार्केट है और मल्टीनेशनल प्रॉफिट मेकिंग कंपनीज जो है सभी एक्सपीरियंस यहाँ कर रहे हैं इंडिया में. यहाँ की जो हेल्थ सर्विस थी वो अभी कारपोरेट की तरफ जा रहे. इंश्योरेंस कंपनीज वगैरह, इन लोगों का बहुत बड़ा रैकेट है कि चलो अब हम पहले 2-2 रुपए 5 रुपए कंसल्टेशन रहते थे, या कभी पेशेंट को फीस सबको सेम रहती थी. ये सब अभी छोटे छोटे हॉस्पिटल्स बंद हो रहे हैं. 5 साल में आपको एक भी हॉस्पिटल इंडिविजुअल दिखाई नहीं देगा. कारपोरेट है. यहाँ 5 रुपए रहते थे, अभी 25,000.
I think
को लगता है कि ये इंटरनेशनल रैकेट है बहुत बड़ा.
No, I don't think I would like to comment on this, whether it is a...
यहाँ लागू करने में.
No, I don't think we'd like to get into that, whether it is a racket or a bracket. I can't say. We should not get into that. All right? So I think thank you very much, everybody. Sorry.
Last question. See, now in India, as he rightly mentioned, that the infrastructure availability of manpower is a major concern. And we ourselves, we have worked for almost 32 hours non-stop during our residency. And that time, like there are the laws in Europe that bus driver cannot drive more than 8 hours because after 8 hours his performance slows down. It's a human limitation.
Correct.
So, but it's happening still in India that we are working as a resident or in many government setup for more than 12 hours in continuous day. So if anything happens during that time, let's suppose there's an obvious negligence. That I have kept some cospies when I was doing that operation for 15 hours of my continuous duty. So that time it's very expected that I may not perform to my optimum of my level and capacity. So do you consider such situation in favor of service provider that he is doing out of his,
You see, that may be a good ground for either saying that compensation be not at a higher amount, or because of the tiredness or continuous, but that should come in evidence.
Correct.
Right?
Yeah.
Yeah.
Suppose I prove.
So you'll have to prove it. You'll have to prove it.
That will,
for 15
so
hours
that
and
will not, then
to
you may not be held liable for guilty for negligence.
So that
That
consideration is
are
there.
reasons beyond your control. What can you
But
do?
sometimes,
yeah.
unavailability of other services. Like I need 3 assistants.
But
There's only 1 assistant in government setup, and I have to struggle like pancreas or pancreatic injury. So I was doing in a limited resource. So I don't.
Yeah,
perform.
but I don't think that could be a good defense, because you can't endanger the life of a patient. So you say you don't. I will not operate till I have 3 assistants,
So can we refuse on that
and
ground?
it might vicariously go on to the management actually. The vicarious liability to the management. Why you made him work for 12 hours? See, no pilot is permitted to fly. After that flying, he has to take rest for 2 days.
Exactly. So why not?
He can't. Yeah, but that is the question which they can't answer. We have to.
This issue.
It's a very important question, but it's something because resident doctors are really working for 18 hours and all that. So
If it is a planned or elective surgery.
yeah.
I'm talking about only emergency.
Emergency.
No, emergency, nobody will punish you. Even Honorable Supreme Court also held, in emergency, whatever you do, it is in good faith to save the life of patient.
Say, I have kept hospice inside.
Suppose if it is a elective surgery, and after this surgery you want to perform another elective surgery. Elective, I am telling elective.
Correct.
So whether you can perform 10 surgeries in one day,
Correct.
this court will ask.
Yeah.
Okay. Or first surgery, second surgery, third surgery.
Elective, I agree. It's not accepted. In emergency, where most of the healthcare service providers, they are put at this extra stress because of lack of manpower.
No, emergency, I won't think. Emergency, no one will see very harsh.
Thank you.
Good evening, sir. Sir,
Is this the last question or the second last question?
last question, sir.
Last
Submission. So first of all, thank you for gracing the event with your presence. The question I'm about to ask is a polemical and rather delicate one, but it is imperative to be touched upon this evening. Recently, case of SGD Chaman Lal was dismissed by Honorable NCDRC. As a doctor, when a case is filed against me, I suffer stigmatization. I am even disgraced, and my reputation is blown off. After 10 years, it is the finding of the Honorable Court that I was not guilty at all. So, is it time that we move towards compensation to doctor for frivolous litigation as well?
Yes, you have all the rights. You can file a civil suit also.
Sir,
first thing, you can file a civil suit. You can file an application for awarding damages to you.
Yeah, whether it will work or not, you don't know, but you can file.
If there is a precedent from honorable courts,
there is no precedent as such, but the right is there. You have a right to approach the civil court for malicious prosecution, right? It will amount to malicious prosecution. You can claim damages, right?
Even defamation?
No defamation.
Say something before the appropriate authority does not amount.
And you will be busy for the next 15 years after that. After filing, another 15 years will be busy. Thank you, ladies and gentlemen. I think we need to stop. Thank you.
On behalf of the Association Surgeons of India, I take this opportunity to thank all the panelists who have spent, I think, our honorable judge has stayed back for 4 hours with us. It's something, it is an extraordinary gesture he has shown. I think that shows his commitment towards better healthcare. That's what I feel. I think as doctors, we also have commitments to do. I think this is the platform, such platforms and such discussions only can bring in more solutions in the future. So thank you very much, sir. You have, yes, sir.